it's a risk. That's what I do. I articulate risks. And the risk was that if the GLO scheme was inconsistent with the HSS scheme, and that might be correct, but if it was inconsistent, then the risk is we would have to reopen up the HSS in order to correct that.
And why is it that the inclusion of somebody like Lord Arbuthnot could build in those risks?
Forgive me, I don't know why Lord Arbuthnot's name is in there. I don't know the context of why that's there.
Can you recall any specific concerns you had as at February 2023 regarding the scheme?
About the GLO scheme?
Well, if we see there, the subject is OHC remediation engagement with Parliament. Does that assist you at all with knowing what your concern was?
I think from recollection, this was a meeting that I was being invited to with interested MPs and postmaster campaigners, including Lord Arbuthnot and others. And the debate was whether I should be invited or not be invited, etc. And it was a critical time at the inquiry as well. I think the next compensation hearing was about imminent. And this was about what were the risks around me attending that meeting prior to coming here for the redress hearings. And that's what it was about. And that's why Lord Arbuthnot might have crept into that paragraph.
Thank you. One more email on the group litigation order scheme. It's Bayes 40656. This is a note of a meeting with Minister Hollinrake on the 25th of May 2023. Yeah. So on a few months from the last email that we saw. If we scroll down the page, we can see there that you attended a meeting. And there's a GLO update over the page, please, page 2. And that says, Minister Hollinrake said he'd seen that Alan Bates had been critical of the slow pace of the GLO scheme and pointed towards disclosure as the issue. SR, I think that's yourself, said the issue is not the slowness of disclosure at present. The Post Office had committed to 32 weeks as an end-to-end process. The issue is that they're waiting for cases to come in, as the process of disclosure can only properly start once cases are received. SR, I think yourself, said in the meantime his team is collecting the base data that they know they'll need. SR said his team are working at risk as the Post Office hasn't received payment for the work yet. Just pausing there, that was a phrase we spoke about yesterday. So as at May 2023, had the government not committed funding to the Post Office's work on the GLO scheme?
So this is, as I said yesterday in my statement, this is a regular occurrence. And I want to be clear to the inquiry on this. Government commit to the funding verbally and in emails, etc., and clearly that commitment is well-meaning, and of course government will pay. But from a legal entity perspective, that has to be crystallised by formalisation. And therefore working at risk is we know we're going to be paid, we know it's all going to be sorted out, but the formal documentation has yet to be in place. Now, optically, I can't cross my arms and say, well, until that formal documentation in place, I'm not going to do anything, because that will be slowing down redress, wouldn't it? So I can't do that, and I won't do that. But I have to explain that to the board to say, and get permission from the board to say, look, I'm making a commitment here that we're working at risk here on the assumption that the government will pay us. And of course they will pay us. But it's getting those formalities and indeed legal advisors more sort of comfortable with that. But I want to be clear, working at risk is not slowing down redress.
CC, I think that's Mr. Creswell, said the Post Office received the contract in January. The delay has been on due to going back and forth on specifics, but he understands that the Post Office is currently operating at risk. So
there's the acceptance from government. They accept that we're working at risk, and they sort of say, don't worry, the money's on its way.
Thank you. Minister Hollinrake said He feels we need to be getting on the front foot here, comms-wise. If the issue is that cases aren't coming through, then we should say this. And SR, yourself, said he would take this on board, as how Alan Bates described the situation is slightly misleading. Can you assist us with what you meant there?
Well, I think it's the first bullet, isn't it, where Mr Bates has been critical of the slow pace of the scheme and pointed towards disclosure as the issue. Disclosure was not the issue because we weren't being asked for disclosure.
Thank you. Finally, on this scheme, what is your current view of the progress of the scheme as at today's date?
Of the GLO?
Yes.
I don't operate it. All I can say is what I heard at the Select Committee in February, when I found it very, very interesting, and hopefully Post Office has helped in that the challenges that the GLO scheme were very similar to the challenges of the OC and HSS schemes in terms of getting cases in, and then lessons can be learnt from that. In terms of the numbers that have come in weren't as expected at the pace expected.
Let's move on then to the Horizon Compensation Review Scheme. Do you have anything to say on that? Any updates as far as you're aware? We'll be hearing from Mr Creswell and others in due course, but is there anything that you're aware of that you think is of note for the inquiry?
Apart from the fact that it's an absolute excellent initiative in terms of clearing this mess up, in terms of the initiative and the impact it's made. It's been absolutely fantastic.
I'd like to move on to a slightly different topic to compensation, and that is the past roles review. Could we please turn to poll 00448307? This is a document of the 30th of October 2023, and it lists you as the chair of the past roles review panel. Is that correct? Were you chair, or are you chair of that panel?
I am indeed.
Please could we turn to poll 00458391. When were you first appointed chair, approximately?
It would have been about the time that is a draft, and some of those names are not on that committee, but it would have been around that time, yeah.
Thank you. So around October 2023.
Yeah.
This is an email chain from December 2023. If we scroll down, please, we can see a number of different names on this email chain. We see, for example, towards the bottom there, on the left-hand side, Caroline Richards. Mm-hmm. She's someone who the inquiry has heard visited a postmaster with Stephen Bradshaw, the investigator. If we scroll down, please, we see at the bottom of the second page the name Melanie Caulfield. These are all in alphabetical order, I think. Melanie Caulfield, thank you very much. Melanie Caulfield was a member of the communications team. She was involved in liaising with the press regarding issues relating to Paula Vennell's Panorama. We've seen, the inquiry's seen an email from her describing the remote access issue as totally loony. If we scroll over the page, please, we see about halfway down Roderick Williams, well known to the inquiry, a witness in the inquiry. He received the Clark advice, Project Zebra. He was involved in notifying the insurers about issues relating to Gareth Jenkins. He was involved in briefing Paula Vennells on issues relating to bugs, errors, and defects. We saw yesterday that email from Mark Underwood regarding fees and criteria to be imposed in the compensation schemes, and he was a recipient of that email. If we scroll down, please, we see on the bottom of page 7 It's an email from yourself, and it's relating to the remediation unit. And you say, yesterday marked a significant milestone in the remediation unit's journey, providing compensation to postmasters and postmistresses all across our mediation programs. You say, yesterday we issued the last HSS offer from the original cohort. This is a significant milestone and one to be recognised. You say a bit further down, it also calls for me to recognise all of you for a job superbly executed. Now, at that time, those names that I've just read out, were they involved in matters relating to the remediation unit?
So, testing my dates here, yeah. But to so Mel Caulfield in particular doesn't work in the remediation unit. She works in comms. So that distribution list would have been an all RU and related, because again, Mel doesn't work for RU. So that would have been a mailing list that would have been used for anybody sort of involved or helped in RU. And at the time, I certainly know that Rob Williams wasn't in the business, and I know certainly Caroline Richards now is not in the business. But they would have been on that circulation list at the time. I don't know where. So certainly Rod would have been out. Caroline, I don't know whether she was still in the business or not at the time. I think she would have been in the business at the time still. But Mel is communications. She's not within RU.
Around that time, though, late 2023, did you have concerns regarding people working in the remediation unit who had those kinds of past roles and past involvements in matters that the inquiry is investigating?
Yes.
If we could please turn to, we see at the beginning of that chain, sorry, if we go to the first page, we can see that it's forwarded to Nick Reed and Lorna Grattan. Were you aware at that time of any concerns that Nick Reed, for example, had about those kinds of individuals working within the remediation unit?
Yes.
Did you see it as a high priority to address?
Yes.
If we could please turn to poll 00448864. This is a group executive meeting from the 13th of March 2024. So we're moving on a few months. And it's page 3 that I'd like to look at. If we scroll down, please, to the section, thank you, on past roles. I think you attended this meeting and spoke to the issue of past roles, is that correct?
Correct.
So SR is yourself, NM is Miss Marriott, Simon Ricaldin and Nicola Marriott spoke to the paper which set out a recommendation on the approach to be taken in relation to the past roles review and staffing in the remediation unit in the light of the change in operational context and political environment. We know that by then there had been the ITV drama. Was that the operational context and political environment, or was it something else?
It was absolutely the TV drama, but also it was clear that the advisory board were very uncomfortable.
Thank you. As a reminder, the past roles review had been commissioned to look at the roles and activities of current employees who may have previously undertaken a role relating to the subject of the inquiry, to examine whether any conflicts or perception of conflicts arose. How long had that been going on by then? I mean, it's March 2024.
So the issue about past roles first came to my attention, and the inquiry had a role to play in that, and I'm grateful to the inquiry for that. In an individual called Brian Trotter came and gave some evidence to the inquiry, and I think that was March 2023. So that's when the issue first came to my attention. I was concerned about that background and that past roles risk that raised, and I escalated that straight to the chief executive, who then mandated the then Chief People Officer to conduct whatever needed to be conducted in terms of review of the issue and the risk and how we were going to mitigate that risk.
We're now here a year after that concern arose. Do you think it was acting quickly enough?
Absolutely not.
And what do you feel was the hold-up?
Inactivity. This is a very delicate area. The first thing was to do the review. And I was very much involved in that review. You see, I actually chaired the forum. And to identify the individuals who might be of concern in terms of not their activities. Again, to be clear, there's no allegations here at all. That's separate. This is nothing to do with Phoenix. There are no allegations against these people. There's no wrongdoing. And we've got to make that really, really clear. There's no evidence of any wrongdoing of these individuals. And therefore, the first thing we had to do is, so if these people were around at the time of interest for the inquiry, what roles were they performing? So we started that exercise by looking at roles. So what roles at the time would the inquiry be interested in? And we came up with a list of investigators, contract managers, etc., that we knew the inquiry were interested in and where there could be potential conflict. So we said, right, here are the roles, and are any of those people, do they occupy those roles at the time?
Why does it take an inquiry to realise that people who worked as investigators, for example, might be people that you don't want in the team that's deciding compensation and redress?
I think that's an excellent question, and one that certainly wasn't addressed at the time. So when that team was built, I don't think that was taken formally into consideration. Now, in my work after Brian Trotter's evidence, in my work that I did look for conflicts policies, and there were conflicts policies, and they were mainly about you can't work for two employers at the same time, that sort of conflict policies. But I did discover there were conflict policies agreed between team members that if there was a case that they had previously been involved in or previously knew any information about, they would then pass it to somebody else who didn't have any background knowledge of those. I was concerned about the lack of formality around that conflict policy, and I escalated that as well. So my regret is, and it is a genuine regret, is that when I came in January 2022, that I didn't do that conflicts check back on in my inherited team, and challenge that, and that I absolutely apologise for, because I think that's something that should have been done. As I said yesterday, that team was sort of leaderless for about 8 months whilst I was being recruited, and I think there was an assumption by the business that conflict check would have happened at the time that team was being built, but it clearly hadn't been.
Who built up that team, do you know?
Well, I think it was my predecessor.
And who's that?
I can't remember the gentleman's name now.
Okay. If we look at the bottom 2 bullet points, we have description about the red category. So colleagues were rated red, however, if they were identified as giving rise to a perceived risk in terms of undermining the integrity and independence of remediation and redress work being done, and in those cases redeployment had been recommended. Since the review had been undertaken, there had been a significant increase in late applications, and the remediation unit work, driven by current external scrutiny and the heightened awareness that was generating, organisational design delays had meant an increase in colleagues who were deemed as red, and there no clarity yet on the government's role in relation to redress going forward and associated processes and procedures. Simon Ricaldin and Nicola Marriott noted the implications arising from a reduction in headcount and the risks posed to redress claim processing times. So you were concerned at this point about, you had 2 problems. One was people were live to the issue of those working in past roles in the remediation unit, but you also have an increased amount of work for the remediation unit to deal with. Is that a fair summary?
Yeah, and I think if to help the inquiry, that the background here, which I think in Karen's evidence as well, was that these excuse me, these people were originally recruited in this space because of their knowledge, their system knowledge. And I talked yesterday about the SFAs and shortfall analysis and the technical expertise and experience required to do that in a professional and appropriate way. So they were there for good reasons and because of their skill base. Now, but as I did explain yesterday as well, we knew the volumes were dropping off, and we also had this issue where through this process that we did into identifying roles, I think the number's been well articulated. There were 27 individuals who were around at the time who were occupying what we deemed as red roles, who were still in the business. And therefore, a proposal was that you could potentially redeploy those individuals to mitigate that risk, that perceived risk. Again, to be clear, we've got unemployment law and all the rest of it. Now, a counter to that would be, well, don't forget at the same time we're now getting increasing volumes in because of the Bates Post Office drama, and therefore what we can't afford to do is slow down redress. So if we redeploy those people, is there a risk we'll slow down redress?
And the decision as at March 2024, as shown here, was that there would be what's referred to as a many to few approach, which is effectively getting rid of those individuals, is it?
Or redeploying, redeploying those individuals. But many to few is you would actually backfill. So you would recruit people, and these individuals would help train the new individuals, and then move off. So you would effectively ring fence them.
Okay. Moving on to April 2024, can we please look at poll 004486449? We then have a board meeting. It's a note of a board meeting that we've seen before, so I'll take it pretty quickly. But if we go to the second page, it sets out there, under past, if we scroll down slightly, it sets out the three categories. There are three categories. One is employees due to give evidence. The second is the past roles people. And the third is those who are in the Project Phoenix category. If we go over the page, there's discussion, page 3, about halfway down. Were you involved in Phoenix at all?
No. Well, if I can clarify that, I think as the evidence of Mr. Reid said, during restorative justice meetings that myself and other post office executives attended, if there was any allegation of wrongdoing by an individual member of staff, current or indeed past, then we would log that, and that will be referred to Project Phoenix. That's my only involvement.
It says there, slightly further down, thank you. It says there at the top, the chair asked NM, that's Ms. Marriott, to provide an overview of category 2, that's the past roles category. She spoke through the category, outlining the work that had been undertaken to assess for conflicts arising from roles associated with the activity covered by the inquiry and current roles, and detailed the employee population that this work had identified. NM noted proposed restructuring. However, this had not been actioned due to the need to retain the workforce given the high number of new applications to HSS. So this is a month later after the many to the few approach had been determined. Am I right to understand from this that in fact that slowed down to some extent because of the new applications to the historic shortfall scheme?
I think you can.
Did you have any concerns about that?
Apologies, can you remind me the date of this board meeting?
This one is April. It's the 29th of April 2024.
I think I had concerns about the pace of the activity, and I was extremely aware of the optics and the concern that I was receiving from the advisory board.
And was there anything you were able to do about that?
I was part of the working party. I was engaged in working the solution. So, and as previously advised, I was actually chairing the forum that determined whether a role was read or not. And therefore we went through, religiously and in very fine detail about the individuals that were occupying those roles at the time, and therefore what category they would be to be determined. It's a very, very sensitive area because you're on the edge of employment legislation and all sorts of things. It's a very, very delicate thing, and these people have done nothing wrong.
There were suggestions, especially from the sub-postmaster non-executive directors, that a suspend first policy should have been approached. What's your view on that?
I'm aware of that approach, and look, this was treated as seriously as it should be, and these were board decisions.
Would you support a suspend first approach or not? Did you support a suspend first approach or not?
These were board decisions, and the board made those decisions. I personally would not support. Whilst investigations were going on in a suspension, no, I personally wouldn't. That would have not been one of my recommendations for the paper.
Thank you. If we scroll over, we can see NM details the proposed approaches in relation to the different employee populations within Category 2, noting the benefits and risks involved. For the 23 red employees, it was proposed that the preferencing exercise was run to understand the appetite for voluntary redundancy or redeployment. If neither of these options were taken, a forced change in employment would be effected, or as a last resort, the employee would be dismissed. It all seems to be dragging on a little bit at this stage, doesn't it?
I agree.
Who do you say is responsible for that?
I think the Grant Thornton report actually articulated better than I could possibly do. Is there is some serious challenges in post office around decision making and making very, very tough decisions, and therefore not wanting to make decisions, and therefore potentially elongating processes. And for lack of better words, and this is not appropriate wording, but kicking things into long grass for a decision later. And I think that combined with some pretty serious cultural issues in this space, I think it was a cauldron of indecisiveness about what to do, including proper legal advice about employment law, etc., what can be done on optics. These conflicts, this is optical, because there's no evidence here that these people are not involved in decision making. They're just involved in a process, and therefore I keep on saying what a sensitive area as it is. So there's a delicate path here to travel. In the meantime, the political environment and what I call the man on the cup of mummers, that the public opinion, optically, the message is clear.
I can take you to an email chain specifically on the topic of Brian Trotter, who's somebody you've already mentioned. If we look at Bayes 40851 and start on page 2, please. At the bottom of page 2, you can see an email from Mr. Brightwell from the Department for Business and Trade to yourself. He says this from Richard Moorhead. An SPM approached me worried that 2 staff involved in Horizon Matters pre-Bates are or have been or may have been involved in redress, Brian Trotter and Mervyn Jones. Helpful to know where these stand, please. If we scroll up, you say Brian Trotter exited by me mid-2023. He gave evidence at the inquiry in late 2022. Previously, he had been a contract manager, hence why he was called as a witness. but after leaving Post Office, he came back as a contractor in the remediation unit, but not in a role with any influence/decision-making, purely admin. As you said, Mr. Trotter was a witness in the inquiry. He was an area manager. He was a contracts manager. We saw him involved in, for example, an email chain in the context of Calendar Square, emails from Anne Chambers of Fujitsu. He was involved in the suspension of sub-postmasters. He was, I think, criticised by Mr. Justice Fraser. What do you say was his purely administrative role? And do you recognise that even in that role, there is a problem if somebody like that is employed in the remediation unit?
It doesn't matter what role he was employed in as a contractor. It's a problem. It should never have happened. It's outrageous that was allowed to happen. It's a blatant conflict of interest. It should have never happened.
And can you assist us with what kind of a role within your unit he was performing?
I am reliably advised it was a purely admin role. There wasn't any influencing in terms of what he was doing. But I would add, not that you've asked me, but I would add, and I've been very clear to the entire executive of Post Office, and I think it's a reflection on probably the cultural environment that we're dealing with here, is that sentence there, BT exited by me mid-2023, that was one of the most difficult things I've had to do in Post Office in terms of working the system in order to exit Mr. Trotter when his fixed-term contract simply expired in mid-2023. It was one of the most difficult things I had to go through in terms of engagement with the right people and the appropriate actions to be taken.
And you spoke about the Grant Thornton report and the indecisiveness. Did you experience any of that in relation to Mr. Trotter?
In spades.
And where was that coming from?
A lot of it by an example was fortuitously or by accident. I actually I met his line manager, who was required to deliver the message as line manager, and she was clearly very, very uncomfortable with being able to do it, and advised me that it might have implications on other people, and nobody's done anything wrong, etc., etc. And therefore, it was clear from her body language, everything, that she was very, very uncomfortable with it. And I said, look, you're uncomfortable. I don't want to put you in a position where you're going to be too uncomfortable. That's fine. And do you want to take the opportunity of somebody else delivering the message? And she took that opportunity. So I escalated that up and somebody else had to deliver it. But the whole process of getting Mr. Trotter into that position, appropriate position, was torturous.
In light of the time and in light of your evidence, I won't take you to, I have a whole series of correspondence that you'll have seen in your bundle. Around this time, there's the letter to Professor Hodges, that's Bays 40843. There is an email chain involving Mr. Moorhead, Professor Moorhead, Lord Arbuthnot, that's Bays 40846, that's July 2024. There's also Bays 40848. Email from Professor Moorhead to Chris Hodges and others, that's Bays 40849, that's August 2024. You'll have seen those chains in your bundle. Do you think that you personally had a sufficient grasp of the risks involved, irrespective of whether those individuals were working in your unit were involved in specific allegations of wrongdoing? Do you think that you understood and were doing enough about the potential risks that were posed by them working within the unit?
I absolutely understood the risks and the potential risks. And as a number of board members will confirm, in terms of making my views clear about what could be and what could be done, what we should do about it. I've been very, very clear.
Final topic from me today is Project Alder, and I want to deal with this very briefly. Could we please bring up onto screen poll 00448-907? This is a report that we've seen before from John Bartlett. It outlines various investigations that were ongoing within the business. If we could please turn to page 12. Page 12 and onwards, it makes clear that outside agencies have been involved in these investigations, and therefore we don't need to deal with them in depth. But just to outline Project Alder, there's 2 slides there. It says the principal allegation is that the senior contractors in the remediation unit caused the handling of compensation claims to go slow in order to extend their well-paid tenure at the post office. DLA Piper was engaged to conduct an independent investigation. If we scroll over, there's an outline of the current situation. A large number of interviews have been conducted, including with yourself. There's no evidence to date about a gravy train. It does say here that there's considerable evidence gathered so far, which shows that some delays could have been avoided and that a contributing factor was the dysfunctional relationship within the remediation unit between the post office staff and contractors. There are 2 or 3 key interviews remaining, but this looks like an established position. There's also evidence of a failure of leadership at several levels in the remediation unit, and that decisions made within the remediation unit are very focused on value for money rather than the best outcome for postmasters, to the detriment of some postmasters. Can you assist us with what the current position is in relation to Project Alder? Any findings? If you could just summarise those for us, that would be very helpful.
Of course I can. The two most significant allegations, as advised there, were that it's interesting in there, the word deliberate is not in there, but the allegations were there. The word deliberate is in the allegation. Is that RU senior members of staff deliberately delayed redress in a non-horizon, by the way, a non-horizon compensation scheme, suspension remuneration. They deliberately delayed redress. And the second allegation was actually, I think it was a named individual, deliberately dragged their feet in order to get their contract renewed. Those are the 2 most significant allegations in there. You asked me yesterday about whether I had enough time to deal with all the things I had to do and whether I had an appropriate resource. It says in that report I was interviewed 4 times. I was interviewed for over 11 and a half hours by DLA on this issue. So you asked me what to summarise what the outcome was, which I'll get to straight away. Those 2 serious allegations, and you cannot make this up, Mr. Blake, those 2 serious allegations were actually withdrawn during the investigation by the individual who made the allegations. In addition, the report concluded that there were no findings about whether redress, so the redress was not delayed at all, and the individual named did not deliberately drag their feet in order to have their contract. So there are no findings at all, but those allegations were actually withdrawn, and the report in the management summary, paragraph 3.2, makes it absolutely crystal clear that the reason why the report was commissioned in the first place was because of these allegations, and the author recognised that the withdrawal of those allegations made the report superfluous. As you say, as you can see, I'm quite passionate about this, because this was a direct, poor reflection on my team, which was totally inappropriate and uncalled for.
I don't know if you've heard the evidence in the inquiry when we heard from the sub-postmaster non-executive directors. There was a suggestion of an over-investigations culture within the post office. Is that something that you agree with, that you share, or what are your views on that?
Mr. Blake, I share with a passion.
and who do you hold responsible for that?
I've been here before with you, Mr. Blake. It's a cultural thing. I truly believe it's a cultural thing. And it's interesting, the new senior management team in have already mentioned it to me about a culture of raising, and absolutely within the rules, raising grievances and raising whistleblowing on a number of issues because it's there, and it is we're in a very sensitive environment. I mean, post office is shot to pieces. Okay, it absolutely and therefore everybody is extremely sensitive. Nobody wants to make a decision. Okay, and every decision they worry about the consequences of making a decision. And he's been in this environment quite understandably because of the bad place that post office has been in. And by the way, it's all true. So it's such a bad place, but the culture is absolutely, that I experience, and I have to caveat that, is that only the bit that I experience, that I have seen culture within post office elsewhere, in the retail business, in many, in procurement, etc., in many other areas, communications, where the culture is clearly not like this. Well, the area that I work in, the culture is very, very challenging. And to answer your question is, there is this environment. I feel very strongly about this. I've worked for 35 years, 38 years now I've worked. And for the best part of 35 years I've worked for NatWest Royal Bank of Scotland, going through a number of different management levels. And for 25 years of those, I've managed people either from one team up to over 1,000. And during those 25 years of managing people, I've never, ever had a grievance against me. I've never had an investigation about me about anything. And this is very personal, Mr. Blake, and I hope you don't mind me sharing it. And I feel very strongly about this. And in those 25 years, never investigation, never agreements, nothing. And in fact, I'm happy to share, 360 feedback on a consistent basis done annually has been outstanding. I've worked for 3 years in post office, and I've been investigated 5 times, Mr. Blake. You've asked me, who do you blame? I don't blame an individual. And I don't blame anybody. I point to the culture that I face. And I think it's really unfair, really, really unfair, to say that culture is across post office, because it's not. Post office keep over 11,500 branches open every single day. It's amazing what they do and how they do it. Cash centres, distribution networks, motivating postmasters, remuneration scheme. I genuinely don't know how. It's a very sophisticated business, and it's amazing how they do it. And the culture in there is absolutely appropriate. I'm only talking about the culture that I've experienced in the last 3 years.
Thank you. Mr. Ricardo, I don't have any further questions. There are questions from core participants. Sir, do you have any questions before we...
Yeah, just one or two. I want to be clear about that last long answer, Mr. Ricardo, which included the phrase, post office is shot to pieces, all right? At one level, that could be taken as a description of the whole of the organization. And if that is accurate, obviously it is extremely concerning. But you seem to have qualified it, in effect, to that part of the post office with which you are most concerned, which I take to be activities around the remediation unit. So could you actually, as clearly as possible, try to define whether you are making a general criticism of the post office as an organization, or whether you were making a specific criticism about a specific part of it.
I think, thank you, Sir Win, for the opportunity for clarification. As I said, I have caveated it, and in terms of there are almost the entire post office I do not experience, and therefore I cannot comment on the culture in the other areas. I am restricting it to me, but I look at the challenges, putting my leadership hat on of post office. I look at the challenges around governance and the issues that have been raised by the inquiry in terms of the board and dysfunctional behaviour at that level as well. And so when I say short, I think a number of issues during my tenure at Post Office have been raised that in terms of challenges of professionalism of how you run a business. And so I think it's a good challenge back, and thank you for the opportunity of clarification, Sir Win. I have to say it's my challenge. I don't see it as a criticism. My cultural challenge is very much in the space that I occupy, and I am frustrated by a number of aspects of it in terms of all I want to do is pay redress as much as I possibly can to postmasters.
But are you telling me, and I'm sorry to put you on the spot, but are you telling me in terms that the culture related to the persons who are leading and determining compensation in the remediation unit is such that it is having a really serious damaging effect on the ability to pay compensation fully, fairly and promptly?
So I'm not going to go that far, because if I was facing that situation, so I would not be here. I would not tolerate that. I would not be here. But is it one of my many challenges? Yes.
So if I modified it to say that the culture, as you describe it, is a significant contributing factor to some of the difficulties which have occurred in paying compensation fully, fairly and promptly, would you agree with that?
I don't think it's impacted on fully, fairly and as timely as possible. I don't think it has impacted on that. But it's another issue to be dealt with, and has impacted in terms of my time, other people's time in dealing with those challenges. So, for example, dealing with the past roles issue has been extremely time-consuming. So
it's a constant challenge. It's a constant challenge.
And therefore, taking my bandwidth to win, does that mean I'm not making decisions on redress? Potentially. Do I feel that has delayed redress or curtailed redress? No, I don't. Because I just work harder.
Right. On past roles, just so that I'm clear, have you now completed whatever work you needed to do in relation to past roles?
Yes, and a plan is now in place around those 27 individuals, and that plan is in course of being executed as we speak, Sir Win.
Right. Well, that in effect is confirmation, I think, of what Ms. McEwen told me.
Correct.
That this was very close to the end of the process. Correct. So that's where we are, yeah.
Yes.
Right. And then finally, just trying to pinpoint who your predecessor may have been, can I mention a name and you tell me if I've got the right person?
Of course you can, Sir Win.
Salter. Mr. Salter.
Declan Salter, thank you very much.
Right. And as I understand it, there was a gap of about 8 months between Mr. Salter departing and you arriving.
Yes. Sir
Fine. Thank you. All right. Those are my questions. Over to the co-participants.
Thank you very much. I think it's going to be Mr. Jacobs first.
Yeah.
Thank you, sir. Mr. Ricardian, good morning. I want to ask you about restorative justice.
All right.
And you deal with restorative justice meetings at paragraph 35 of your 6th witness statement. And these are meetings where postmasters meet you and Mr. Reid and other senior executives and relay their experiences and concerns in relation to the scandal. That's right, isn't it?
It is.
And you may or you may not know, but Howe & Co, who instruct me, raised this issue with the inquiry on the 13th of October 2022. And since the 22nd of June 2023, there have been 20 days of restorative justice meetings that you have held. I think you've been to every single meeting, haven't you?
I have.
And 57 of our clients, along with at least one supporting family member, attended those meetings, and over 114 individuals and victims have met you and other directors. Is that right?
That's right.
And here today are Maureen McKelvey, who sits next to me, Heather Early, and behind me, Fiona Elliott and Catherine McElhenney. They are 3 rows behind me. There wasn't enough room on the row for them. They were present at the first meeting with you in Belfast in June 2023. Is that right?
Yes, that's right.
And they're still waiting for their compensation claims to conclude. And I know that you're going to meet them next month, aren't you, to discuss
Yes,
their
I was hoping to meet them
position.
today.
You were
Yes.
indeed. Other matters have intervened. So very generally, I don't want to discuss their individual cases. Obviously, you're going to be meeting with them to talk about those cases. Where these meetings take place, and you or Post Office directors give assurances that everything is being done to deal with things very quickly in terms of compensation, perhaps assurances are given that matters will be looked at within months. What can you do to make good on those assurances now that we're in 2024 coming into 2025, if claims are still ongoing?
What can I do? But and I am grateful because the 4 lovely ladies that you refer to, you know, they do approach me directly. You know, we've had this meeting with you. Can you help me with where is my case? And I'm very comfortable, by the way, with those sort of approaches. Again, we can't talk about individual cases,
Of course,
but they are split across. To Mr. Blake's point yesterday, they are split across the Post Office and the government schemes. And in terms of if the case is in the government space, I am limited in terms of what I can do about that, but I will escalate within the government in terms of using my contacts within the government to say, I've had a concerning email and approach about the speed or whatever it is. Can you help? And I understand that they do proactively reach out to people to say this is where your case is, and we have this SLA of working within X days, etc., etc. In terms of the cases that are in my schemes, and it's interesting I call them my schemes, isn't it? Is I escalate within my teams to say, so why are we waiting so long on this? What's going on in that case? Why haven't we received the medical report on that? So I will escalate accordingly. So so your question is what can I do? And I'm conscious I'm talking too fast. Sorry. What can I do is I can escalate and intervene to try and help.
thank you. The feedback from our clients who've attended these meetings has been generally very positive. People say, I'm glad. I'm reading a quote from a client now. They listened to our experiences and I felt they were appalled by our stories. Nick and Simon were very engaged with the impact the Post Office had on our lives. I'm assuming that's Nick Reid, who's behind me as well. You say in your statement that these meetings help you to understand the wide-reaching and long-lasting effects of the scandal on each person and their families. What messages have you felt that it is important to pass on from these meetings?
Where do you want me to start?
Well, what are the main take-home points? For example, Miss McKelvey was acquitted in 2007, and there was no inquiry, no publication of her trial, and other cases where the Post Office secured convictions. They were crowing from the rooftops, that sort of thing.
Yeah.
These stark issues.
So to be clear, Nick and I mandated ourselves especially coming back from Belfast. It made a huge impression. And we mandated ourselves that people needed to, people in post office needed to hear these stories. And that's exactly what we did. And we started from the top. We started at board meetings. When we came back from restorative justice, we mandated ourselves to communicate down, cascade down these horrific stories. Okay? And they're not stories. You can use the word stories if it's made up. This is made up. This is real life. And they're absolutely horrific. And my apologies again for the experiences that you ladies have been through. It's unforgivable. And Nick and I made ourselves to ensure that those messages got through. And indeed, as a result of that, there is a sort of training program, a governor's training program that's now in place that actually tells some of these stories. I think they take snippets from the Panorama program and snippets from the inquiry when people were giving their witness statements, in terms of cascading those messages about how serious this actually was. And is it a bit of a wake-up call? This is the place we've come from, and we must ensure this never, ever happens again. This is not... Of course it's about the shortfall. Of course it's about the Horizon system. But you know what this is really about? This is about the journey that Post Office took people through. And that's the issue. Of course it's the IT issue. Of course it's the technology thing and the alleged potential cover-up, etc., etc. But it's actually the way that Post Office spoke to people and dealt with these issues is absolutely disgraceful.
You talk about cascading back, and in your witness statement, you say at paragraph 38 that following the meetings, you ensure each of the victims' experiences is shared with the executive team.
Yes.
Which members of the executive team in particular do you share these with? How does that work?
So I usually post a restorative justice meeting. It's usually a SEG meeting, which was GE, and now it's SEG. And I have the opportunity to download more and often with the senior exec who was with me at the time. So we sort of do a bit of a joint approach. It will be the executive team.
But part of our clients' concerns are that there's been a churn in the executive team. People move on. And these experiences need to be shared throughout the whole company. Do you agree?
I agree.
And do you accept that the culture at the post office is still very much a work in progress?
Yes.
You've heard the evidence of Mr. Ismail and Mr. Jacobs
yes.
in that regard. So what proposals do you have to ensure that the experiences of people like my clients who are with me today are communicated throughout the whole of the post office, not just the executives who may move on in a couple of years?
Yeah. So, and there are executives who have attended these who have not moved on or are not moving on. So there are some there already who will continue. Karen is a great example. Karen has done a couple of restorative justice meetings, and she is very proactive in communicating the message down. And part of one of our many work streams is to understand and help build whatever a legacy means, i.e. something permanent that ensures that these stories are never ever forgotten about.
Will these stories be dealt within the strategic review that the Post Office is conducting?
Not necessarily. Yet to be determined about how they are. I'll give you an example of at a higher level in terms of in the Post Office head office at Wood Street. There is a timeline of where Post Office came from, all the way from Wagon and Horses, etc., all the way through. And in there, if you visit it, there is a recognition of the Horizon scandal. So it's formally on the timeline. It's formally embedded in history. Now it's important that these journeys that many postmasters experience, these awful journeys, that they're embroiled and they're embedded in the understanding of Post Office and to ensure it never happens again.
I want to ask you about wider restorative justice, and this is something that was raised in correspondence back in December 2022 with the inquiry. And the proposals that those who instruct me have put forward are for a number of measures that go beyond simple payments of compensation. And it's not an exhaustive list, but I'm just going to tell you what they are and ask you questions about them. So the first proposal is for ongoing psychiatric and counselling support for sub-postmasters and their families. Mm-hmm. Second is bursaries to assist with the retraining of postmasters and for the education of their children whose education was disrupted by the scandal. Then a tangible memorial scheme to mark this as the largest miscarriage of justice in British legal history that sympathetically records the experiences of the sub-postmasters and how profoundly they and their communities were affected. And then steps to restore reputations within local communities, engagement with the local press. What steps have Post Office taken to bring these sort of schemes about?
So, a number of those opportunities have already been taken. So, in a restorative justice meeting, we do offer, is there anything we can do to help you? Now, we also recognise, money's not going to fix this. These ladies know that. Money ain't going to fix this. So what else can you do? Now, and it's about, there's a journey here. And if those restorative justice meetings mean they can move 1 millimetre towards a better place on that journey, then that's a success. And many what appear innocuous requests, actually we can do, and we have done, articles in local press about complete exoneration because of the stigma in a particular area. We've done those sort of things. Offering references, simple things like that. One lady I met wanted to have the exoneration signed by Nick Reed that a conviction had been overturned because she wanted to put it in her toilet next to the conviction that she'd had. But to your point, all those other things that you've mentioned are all being considered in terms of, so what legacy are we going to leave here to reflect this?
The point I'm making is that this isn't really something for individuals to ask for. There will be many people who were affected by the scandal who feel too traumatised to even meet with Post Office. Is there a plan for a wider restorative justice scheme, for example, to include straight-out compensation for the families who were family members who might not form part of the existing schemes? Is there any provision that's being planned for a wider scheme, a statement of principles as to what Post Office will do, rather than just individual offers?
So there is a working party that is pulling together proposed ideas of what legacy we should leave, a bursary, etc., in terms of a legacy, something to be referred to, something to be used in the future. You specifically talked about friends and immediate relatives. We have had an approach from a group representing the children of victims, and we are meeting them shortly to listen to their story. Now they've already met. I understand they've already met with Fizitsu, and their request is in their request is not necessarily to talk about compensation. They want to tell the story, and absolutely we should listen to their story.
What about Fujitsu? Paul Patterson is being recalled to give evidence on the 11th of November. Has he contacted you, or has anyone in Fujitsu contacted you about restorative justice proposals?
Not me, no. Not me personally.
We'll hear what he says about this next week. But my question for you is, do you think it would be appropriate for Post Office to speak to them about these issues, to speak to Fujitsu?
I think all options should be explored.
When do you think these restorative justice proposals that you've outlined will be implemented?
If they're implemented, and the thorny issue of funding, as ever, will have to come up, outrageous although it does appear to be, then it will certainly, I would suggest, it would have to be in the next year, they would have to establish something. I don't know is the answer, but I'm trying not to put a timescale on it, but it's recognised that it's something that should be done.
I need to ask if I have any further questions, Doris.
Just turn your microphone on. So give me one moment to just speak to Gina.
Sorry, hang on. I can't quite hear what...
So that was my interruption. We need to speak to one moment for Mr. Jacobs about one matter of further questioning for Mr. Recalden.
Thank you. I've got one question to ask you, a very good point that Mr. Steen has asked me to raise. This inquiry is going to finish at the end of this year, isn't it?
Yes.
The hearings. How can there be any clarity and oversight by the inquiry in relation to restorative justice if the Post Office won't commit to a programme between now and the end of this year?
Well, I can absolutely give you assurance it is an issue that is live and that is being discussed as we speak in terms of what I had a meeting about it literally last week. So I can give you that commitment that this issue is not going away. This opportunity is not going away. I'm sure Sir Wynne will make his own mind up around how that's incorporated into the inquiry. But you have my assurance that this is absolutely work in progress. I don't know what more I can give there. Apologies.
Will you commit to providing a report in relation to proposals and progress before the final report of this inquiry, so that this is something that will be considered and sub-persons will know what the proposals are and it will be part of the inquiry process?
I think that's absolutely reasonable.
So you will commit to do that?
I will commit to the proposal of what we should do. In absolutely, yes.
I have no further questions.
Thank you.
I'm grateful.
Thank you. So if we could take our morning break now, and then we have questions from two further court participants, I believe.
Right, fine. So what time shall we resume?
Half past?
10:30? Yeah.
Thank you. Thank you. So we're going to hear from Ms Page and then Mr Maloney.
Yeah.
Mr O'Caldon, do you take responsibility for the mess that the post office compensation schemes are in?
I feel very accountable for the state of the compensation schemes are in. I make myself accountable for them.
Should you have resigned by now?
That's a good question. I think there is a very, very strong argument that maybe I should have done.
Do you think your mistake was to accept the job even though you knew that the post office should not be running the compensation schemes itself?
No, absolutely not.
Is that why they're not working though?
I haven't said they're not working. Nobody's said to me they're not working.
You tell us, no doubt sincerely, that the schemes you run are not bureaucratic, that they are sympathetic. You say you don't recognise the idea that they were set up to deter applicants through tough eligibility criteria, evidential requirements. And yet our clients tell us the opposite. And the fact is nowhere near enough of their claims have been resolved. After all this time, do you not accept that the problem is the very one that you identified in your interview? Too many of the people administering the scheme are not independent.
No, I don't accept that. I don't accept that too many people are not independent enough. I think no, I don't accept that.
In one of the emails, and I'll just give the reference rather than bringing it up, Bayes 0000849. That's the email chain with Professor Moorhead from the Horizon Compensation Board. And in it you tell him that 73 people who worked for the post office over the 20-year period that the inquiry is looking at, 73 of those people were found to be working in the remediation unit. Now, those are people who worked in the post office when it maintained a fortress mentality towards sub-postmasters. So whatever they say to you and whatever they say to themselves, they are effectively the old guard, aren't they?
I don't know what old guard means. I recognise the number. That I think that note was to Chris Hodge, the chair of the advisory board, and that number is a number of how many people were working in post office at the time who are currently in RU. At the time we're in RU. That's not where they used to occupy roles that the inquiry is of interest to the inquiry. That's a completely different number. That number is the 27 number that has been articulated here. So I was asking the specific question that the advisory board were asking me about how many were working at the time, and many of these were counter clerks.
Yes.
Many, i.e. roles which would of not interest to the inquiry.
But nevertheless, they grew up in a post office which encouraged them to think of postmasters, sub-postmasters as the enemy. And that's why your unit has a culture which gives claimants a hard time, no?
I don't agree with that statement.
They're asked to provide documents from many years ago, sometimes documents which the post office would have sent to them in the first place, or surely should have kept on file. They're asked to provide further and further updated medical records, as we've already heard about Miss Skinner's case, but she's not alone in this. This is the sort of conduct where postmasters are made to prove every point. Do you not recognise that?
No.
You've told this inquiry that you are or were outraged that Brian Trotter was still in the unit, but you've described how hard it was to get rid of him and how even at the end of his fixed-term contract, his line manager, i.e. a member of your unit, would not deal with it, felt that it would impact badly on others, felt that he'd done nothing wrong. That shows the rot in your unit, doesn't it, Mr. O'Caldon?
I think I've been clear with the inquiry in the last session about the culture that I face. And forgive me, I've never used the term get rid. That's disrespectful. I've never used that term.
No, but the term is not the point. It's the people around
It is the point,
Mr.
because
Trotter.
it's about respect. It's about
But
respect of individuals.
It's the people around Mr. Trotter, not just Mr. Trotter himself, that's the issue. Everyone in the unit affects the people around them. And you've described how his line manager was unable to see the point, was unable to see why he should be exited, or I think that's the term you like. She couldn't see the point, could she? He's done nothing wrong, she said.
I didn't say that. I said, and hopefully the script will help me, I think I said she was clearly uncomfortable with delivering the message. And I asked her, are you uncomfortable in doing this? And she said, yes. I said, would you like somebody else to deliver it? And she said, yes, I would. So I took her up on that option.
Here's an example of how having these people in your unit can play out. Mr. Shidju, one of our clients, applied to the HSS, and Caroline Richards attended a good faith meeting in his case. Caroline Richards, who Mr. Blake pointed out to you, had been an investigator. She attended that good faith meeting to explain the frankly risible £2,000 offer that was being made to Mr. Shidju. Following that meeting, she was the main point of contact for Mr. Shidju and for Mr. Marshall, his lawyer. And it then transpired that she had been an investigator, which had never been disclosed. Mr. Marshall wrote to the post office asking about her role, and there was no reply from April 2024 all the way through until September 2024, when Post Office explained who she was and that she had worked as, quotes, dispute manager from May 22 to April 2024, so in other words, nearly 2 years. Now, is it a coincidence that she was removed from being the disputes manager in the same month that Mr. Marshall wrote about it? Or is it another case like Mr. Trotter of somebody only being exited once they had been caught?
I don't know whether that's coincidence or not. I can't talk about individual cases, and apologies for that. What I do know is that Caroline Richards is no longer working in the remediation unit.
Why did it take so long to admit what had been going on?
I'm not quite sure what going on is.
Well, 2 years of her working as disputes manager and then many months before that was confirmed. Why did it take so long to admit that she was in that role when she plainly shouldn't have been?
I don't think there's any. So these individuals are not decision makers around that. They are in roles which do not require decisions. So
she attended a good faith meeting.
Yes, she did.
Do you not see the problem?
Good faith meetings are not decision-making meetings. I recognise the optic. Of course I do. I recognise the optic of that.
Is it about the optic, or is it about the reality that she should not have been in that role?
And the fact that individual has been moved out is a recognition of that. And I'm aware of the case. It's really difficult to what individual cases but you know, absolutely from my understanding of the case and in terms of the individual, I apologise that risk has become apparent, and I believe that Post Office have dealt with that risk.
These claimants are not difficult people, are they, Mr. Ricaldin? They want to settle and move on, but your schemes are failing to deliver, aren't they?
These people are wonderful people.
In the circumstances of significant delays, interim payments are crucial, aren't they? Because it's what makes the difference for people who are sometimes very desperate between being able to carry on to get full and fair compensation and giving up, isn't it? The interim payment can be that difference.
Yes.
And yet you told us yesterday that the department had prevailed upon you not to offer interim payments and countermanded interims that had been authorised.
I did.
You also told us that in the HSS scheme, if an offer is made but not accepted, people will receive the offer as an interim payment if they ask. Why make them ask, Mr. Ricaldin?
I don't think I said that. If I do, I apologise. I think I said that if they dispute their offer, if we make an offer and they say, no, we dispute it, we in that letter, we offer them 100%
Why not just send them the money?
They have to accept it. So we have to they have to sign something to say we accept that interim payment. So it's just an administration thing. But the offer of that payment is in that dispute letter.
Well, then there's HSF.
Yeah.
You've been told directly by our clients, Ms. Falstead and Ms. Skinner, that HSF press every advantage on behalf of their client, the Post Office, just as they did when settling the GLO. Alan Watts, lead partner of Post Office Compensation, also responsible for negotiating the 2019 GLO settlement. Catherine Emmanuel, the recipient of a highly contentious email from Roderick Williams, has conduct of much of the compensation arrangements. It's an obvious problem. It was an obvious problem from the start. And yet there's HSF, one of the most expensive firms in the country, still there, no doubt getting paid faster than the SPMs. Why?
Sorry, the question is why are HSF
Why
still
are
there?
they still there?
Because they're still instructed by Post Office on certain cases. So they, as you know, they operate the back office, the working environment, the operational engine of the HSS, and they still advise Post Office on the OC claims. Much more of that OC process is over the time of my tenure is now with Post Office. But there is the independent panel, and that's the key thing about OC, is that Sir Gary's there now to provide that independence for anything. And it's just, Mr. Blake mentioned it earlier, that Sir Gary's services in terms of opining on those cases has yet to be utilised. I would encourage, absolutely encourage, for the usage of Sir Gary.
There's another structural problem, I would suggest, with the HSS scheme. You've told us that it's built on the principle that redress can only be paid to the personal legal entity that the Post Office contracts with. And that might have worked perfectly well as a principle, were it not for the history, because as we've learned, at no stage over the 20-year period that we're looking at did the Post Office make sure that every branch had a clear and well understood contract in place. Have you taken that on board? Are there any processes to ensure that both the Post Office and the applicant agree that the claim is actually based on the correct contract?
I don't know how to answer that question. I go back to the scheme. In terms of the scheme is there to deal with any entity who has a contract with Post Office, has a contract with Post Office.
Well, here's the difficulty, and I'll give you two examples, but they will by no means be the only people, I'm sure, in this situation. Applicants who didn't necessarily have the contract are being rejected, even though it's clear that there is no eligible person left to claim. So first of all, I'll talk about Mr. Colin Savage. He worked in partnership with his father at a branch. When his father became unwell, he was treated as if he was the postmaster. Importantly, he was reported to the Procurator of Fiscal as if he was the postmaster. He was interviewed about the shortfalls criminally as if he was the postmaster. His father has passed away. The partnership no longer exists, and his claim has been rejected. Post Office say he has no contractual relationship. And this is essentially the same problem faced by Gary Jayakanthan, who I'm sure you've already heard about, the tragic case of her husband who took his own life after the post office goons came for him. And her claim was rejected on the basis that the company he operated through has been dissolved. These are people who are the obvious only person who could claim, because there is no other person or legal entity in existence that could claim, and yet they are being rejected. Do you see the problem?
I do. I absolutely do see the problem. And in terms of, I think we're engagement on the second. I can't talk about individual cases. I really apologise.
The principle is the point.
I understand that. And in that first case, I do not I recognise the second case. I do not recognise that first case. But you mentioned partnership there. If you'd like to give me further details outside this forum, I'm more than happy to look at that. But I don't recognise it.
Well, we certainly can give you details.
Sorry, can I just interrupt a moment? Because I don't want to be too bogged down in the individual case. But I am interested in the process, Mr. Ricaldin, that should follow when, for example, an applicant is rejected on the basis, shall we say, that they were not the contracting party. Now, if that is disputed, what should be the next step, and how quickly should it happen?
So for an eligibility issue, it sounds as though this is an eligibility issue, then they can absolutely have the right to challenge that rejection of eligibility, and that would come into my governance. And then we would say, well, we would look at it to say, well, is there some more information we need to clear up this eligibility challenge?
Right.
I think in my evidence, talked to Mr. Blake, he asked me how many of those cases there were, and I think there are a handful of those cases.
Sure, but
there is a process.
So the process is to go back to post office. What about going to someone independent? At what stage does that happen? If there's an impasse, both sides are acting in good faith. They simply can't agree, all right?
Yep.
At what point does an independent panel or person cut the knot, so to speak, and make a decision?
Well, then we can escalate it, and I think we have escalated similar issues into the panel, into the independent panel to make that call.
In the overturned conviction process, that would go to Sagari and his panel.
Yeah, in an overturned conviction, that would be an opportunity, correct. And
in HSS, it would go through the various stages, which ultimately would lead to a mediation or arbitration. At the moment, there's no appeal process that you can use.
No, I'm suggesting actually that if it's an eligibility issue, that can go to the independent panel for them to opine.
The same panel that decides the compensation.
Yes.
Except that would be non-binding, would it not? Because they don't bind anybody, but the post always so far has accepted what they've said.
Thank you, Sir. Correct.
Okay, fine. So I've got the process.
Yes.
Thank you, Ms. Page. I think we have to leave it with the process, if we may.
Thank you, sir. Just then two final bones of contention, if I may. Firstly, for many sub-postmasters who were prosecuted, they gave the post office the money which was said to be the Horizon shortfall, either as compensation or confiscation.
That's right.
And those who have had their overturned convictions obviously should receive that back with compound interest, agreed? Mm-hmm. Why hasn't that been carried out proactively? Mr. Carlier, who sits at the end of the bench here, had his conviction overturned in 2021. He borrowed £22,000 from his late mother, and he still hasn't had that money back. Why hasn't this been done proactively? Why does it wait for the claimant to ask?
I don't know, and I understand that other have been done proactively. So it's a good shout. Thank you. I'll look at that because I don't know why. Because others I know have been.
Well, thank you. No doubt Mr. Carlier will look forward to that, and no doubt others too. And then finally this, and this is a tricky one, I acknowledge, but many sub-postmasters have described how they spent weeks, months, sometimes even years covering shortfalls from their own money before running out of people they could borrow from. And obviously those figures won't show in Horizon. What effort has been made to try to think about how to compensate people for that?
Compensate them for the monies they've put into.
Yes.
Right. But, so if they've had a shortfall and they've used their savings to make good,
Yes.
to balance the books, then I might have missed the point, and I apologise if I have. Isn't that not an HSS claim?
Well, as I understand it, the HSS claim only works if the shortfall shows on horizon. But if they've been covering the loss, as many of them did before they started to say, I just can't do this anymore, Horizon won't tell you how much they've done, have they?
The scheme activates when the shortfall has been settled, so we can see the cash coming in, and so you know the scheme is activated by a shortfall and its settlement.
I see.
And therefore that would be an HSS claim.
So
I might have misinterpreted that.
no,
and I
that
apologise
may
if I
well
have.
it may well be that I'm thinking about it from the perspective of those who have had their convictions overturned.
Yeah. Okay. Understood.
And under those
Understood.
under those circumstances, does that mean that they should apply to the HSS?
No, they should get that redress. They should get it through the OC process.
And is that something that you can take forward? Because again, we have clients who don't have that, have not had that sort of compensation repaid.
Well, I need to know about that then,
Yeah.
because if that is the case, they should have been. And I apologise if they haven't been. But
Right.
that's the process. The process is wrapped up in that. So I'm very interested in hearing about those cases, please.
Thank
but
you.
In relation to that, Mr. Ricaldin, it surely is, it's inherent in the fact that they're convicted that there was, at the time, alleged to be a loss,
Correct.
which
Absolutely.
has now been shown to be wrong, and so the figure just simply needs to be accepted, does
Correct.
it not?
Correct.
Well, I'm looking at two slightly different losses, sir. I apologise if I'm not making myself clear, but there's obviously the loss which showed, and they were they were prosecuted.
Other occasions when they put money in,
Yes.
which was not the subject of a charge. That's what you're talking about, is it, Ms.
Exactly. So previous to whatever shortfall
Yeah.
they were prosecuted over. So that's the bit that I was asking about. But I think we're all clear now, and you're saying that they should be recompensed for that.
Correct.
Thank you.
Yeah, fine. Thank you, Ms. Page. Mr. Maloney.
Thank you, sir. Mr. Ricaldin, I'd just like to ask you some questions about aspects of the working of the schemes. And the first matter I'd like to ask you about is the £600,000 offer in the OC context, if I can use that abbreviation, the overturned convictions. The £600,000 offer is not a floor for compensation, is it? You're not guaranteed £600,000 within the OC process.
Correct.
Yeah.
Well, sorry. You are if you accept it as full and final
So
settlement.
I'll ask you a few more questions, and then that will elucidate essentially what I think you were about to say. During the OC scheme, a schedule of losses submitted by the claimant, or can be, and this was always the case before the £600,000 offer, schedule of losses submitted, and there might be disagreement between the claimant and post office about the appropriate quantum for the different heads of loss. And as an example and no more, it's possible that a postmaster might submit a claim for, let's say, £650,000, and post office might come back and say, well, actually, we only think it's worth 550. Once a postmaster has submitted a schedule of loss, after the implementation of the £600,000 offer, once a postmaster has submitted a schedule of loss, the £600,000 offer is no longer available to them, is it?
Correct.
Yeah. Would you agree that some postmasters who have claims which are more than, but relatively close to £600,000 might feel pressure in those circumstances to accept the offer of £600,000 rather than risk months of delay in negotiation, perhaps even ending with an offer of less than £600,000 that they have to fight on to the independent panel?
Mr Maloney, you know my views. My views were articulated in the email which has been shared with the inquiry. So I do agree with you. That is a risk.
Yeah. And can I just give one more illustration of how, in particular, that might occur within the OC process? That many of the claims involve heads of damage associated with loss of opportunity.
Yes.
Yeah. For example, a classic loss of opportunity is a plan to take on another branch that didn't come to fruition because all plans were interrupted by shortfall, termination, prosecution, conviction, and so on. Yep. So there was that loss of opportunity. And inevitably, such claims involve a degree of estimation of losses over many years, don't they?
Yes, yes.
And so there's a potential for significant difference between the parties in the estimation of those losses.
Yeah.
So just to use an example, it might be that a claim for £800,000, just to move it well beyond the 600, might be assessed as only worth 450 in response. And again, that's a classic situation where that pressure might be felt by the postmaster to essentially resolve the claim rather than face stress upon stress of pursuing negotiations around that figure and going to the independent panel. Did you always understand that the £600,000 was not a floor when it came in?
I think, to be fair, yes. Yeah. So, and again, that email which the inquiry has kindly circulated in the bundle, I think, that was me clarifying that, because if it is a minimum payment, then I've got 60 cases here that I can quickly top up to 600,000, and they made it clear, no, it's not. This is not a minimum payment, and I think the government have been quite clear on that in terms of the 600,000 was designed to get to settlements, and the I'll call risk. I've shared the risk. The risk of that is, as you have beautifully, if I might say, articulated in those two examples, of does the postmaster therefore feel under pressure to accept that because it's too much hassle to fight for your 800, you know what? Because what happens if it does come out at 450? I'm only going to get 450, as opposed to I could take 600 now. So why take the risk? Yeah. And is that pressure? And I understand that. And also the ones on the cusp, where the legal advisors are saying, you know what? It looks about 650, 625, but you could settle for 600. Is that pressure? Is that fair?
And you know, of course, don't you, Mr. Ricaldin, that postmasters making applications are often, even now, very vulnerable, aren't they?
Absolutely.
They face financial pressures no matter the interim payments, because the interim payments are often having to be used for debts that have been built up over many years as a result of what happened with the conviction. So they are vulnerable in terms of those pressures, aren't they?
And they've been waiting too long, Mr. Maloney.
Yeah. Can I now move on just to ask you some questions about the HSS, the Horizon Shortfall Scheme? And first of all, about the relationship between, if we can describe it as a relationship between, as it were, legal representation and the potential for increased determinations of compensation offers following a panel assessment.
Yep.
Lawyers for claimants are not involved, just to reiterate, lawyers for claimants are not involved until after the first offer, are they?
Correct.
Yeah. To put it another way,
they can be involved.
There's no funding available for lawyers But of course, looking at it realistically, most postmasters are in the position where they can't afford. They can't afford to instruct lawyers at that stage, can they?
No objections.
Yeah, and so. Post Office, you said yesterday, wanted the process to be legally light. You accept, of course, though, that it's not so light on Post Office side, is it? Because there are solicitors who've been instructed to, as it were, deal with the initial application and assess it before it goes to the panel. And that's a nod, Mr. Ricaldin, but I believe you might be in trouble for not saying the word yes.
I agree.
And I've just seen that you would have been in trouble. Thank you for saying yes, Mr. Ricaldin.
But it was a nod.
Yeah. Now, we obviously I can't speak for all claimants, but we've seen from the correspondence between Hudgell Solicitors and you that there have been substantially increased offers in relation to cases where they've had the benefit of legal advice and there's been a redetermination of their claim. And could we please put up HUJ 707, please, that Mr. Blake took you to yesterday, Mr. Ricardin, and he identified 4 examples.
That's right. Yeah.
Of those increases. There's one example I want to take you to in a moment. And thank you. If we could stay on that page and go down towards the bottom. Just to, as it were, examine why these figures may be so substantially increased. It is sometimes, isn't it, because of the identification of additional heads of loss. And there's a nod again there, Mr. Riccardi. I'm sorry, but if you could, but yes, there's, I believe, the indication. And indeed, you know that was something that we alighted on in our compensation submissions as long ago as the 10th of June 2022 for the inquiries, compensation hearing in July 2022, that concern about missing heads of loss.
I do recall that, yes.
Back in 2022, a number of small HSS claims had been settled, and it was thought that the more complex claims were the ones that were outstanding and would take a long time to be dealt with. Can we just have a look at number 4 on this page, Mr. Ricardin, please, which is, we see it's the one Mr. Blake took, one of those that Mr. Blake took you to yesterday. It's just 4,500 to close to 134. Now, would you agree on the basis of that, and I don't suggest this applies to all small settlements, but would you agree on the basis of that it's not safe to assume that all small claims have been properly settled?
Are you suggesting? Sorry, can you repeat that question again?
We see £4,000 is a relatively small claim.
Yeah.
Back in 2022, there was a degree of confidence that the small claim, a lot of the small claims had been properly settled,
yeah,
and that it was the more complex ones that were outstanding. Would you agree, and I don't suggest this applies to all the small settlements, but that is an illustration of how it would be wrong to assume that all of the small cases have been safely settled in the absence of legal advice?
I think there is a case here that looks like a small, and I don't know whether that's an offer or a settlement. I'll need to know more context behind this case, because I think what may have happened is in the lawyers have done the usual excellent job in identifying additional heads of loss and additional information to make that significant jump. So I'm not quite sure whether you can transfer that into all small offers are unsafe.
No, I was.
And you're not going that far.
I was reversing that because I'm saying it'd be wrong to assume that they all are safe.
Yes, correct.
So, and that perhaps I hope you'd agree is an illustration of why it'd be wrong to assume that they all are safe.
Yes.
And we see because that is a revised offer in 2024. Now, just if I can just use this as an example for another potential concern, is that that 4,500 going to 134 would not be saved by the 75,000 offer, would it? So we have a situation where we have small offers, and then, well, the 75,000 will cover that. But that wouldn't save that, would it?
No.
No. And just to slightly explain that in slightly more detail, a person who'd received £4,000, a postmaster in financial difficulties, might consider £75,000 to be an offer that could not be refused. It's a very generous offer, it might be thought. But once that offer was accepted, there would be no potential for appeal of that, would there?
That's correct. So again, this is the motivation behind settlement.
Yeah.
So they were keen to get settlement, so people can move on in their lives. And therefore, in that example, absolutely, if the 75,000 were offered on your line 4, and they accepted it, they would be walking away from their appeal rights.
Yeah. And accordingly, given the process of the, they essentially might be in the position where they've lost out on £58,000 by not being able to pursue that appeal.
Correct. But I would have hoped that that would have been an informed decision.
Yeah, yeah. Are you able to help with this? It's right, isn't it, that so far as the IAP is concerned, the Independent Appeals Process, are you aware there's been no consultation with postmaster legal representatives on the proposed structure of it?
I'm pretty sure there hasn't been. It's very much a government initiative at the moment, so no doubt I would suggest that might be coming, but I'm not aware of any engagement so far.
Thank you. Can I just deal very briefly with one issue of evidential uncertainty?
Yeah.
You said yesterday that you believe that evidential uncertainty is always resolved in favour of the postmaster. I don't suggest that evidential uncertainty leads to, as it were, the complete dismissal of a claim under a particular head of loss, but it can reduce the level of payment if there isn't sufficient, as it were, documentary proof, can't it?
You are referring to potential discounts
Yeah.
to the amount being claimed because of the evidence that has been produced.
That's it.
I sort of, and I guess I wouldn't I, Mr. Maloney, but I might see it a slightly different way, if I can just share that.
Of course.
Is a different optic on it to say, so let's use an example that the claim is for £100,000, but because there's, and it does say this in the letters, I appreciate it says this, but because the evidential uncertainty, we're going to discount by 25%, and therefore our offer is 75,000. That's an example that you might be using.
Precisely, and all I wanted to just clear up, Mr. Ricaldin, and I'm not suggesting that anything that you said yesterday was wrong, but there may be, as it were, a reduction in the payment for the evidential uncertainty. But it wouldn't be a dismissal of the head, simply a reduction.
Correct. Yeah. And I think there is another opportunity here, but I would say this, wouldn't I, is that actually the evidence that's been produced on those is not enough. Is not enough. Is actually zero. So the claim is for 100,000, but on the evidence that has been produced is zero. But because the overall claim, the overall story, and the overall approach, actually, we are going to pay 75,000 of that. It's a different optic. I understand that, but it reflects on the evidential standard. So because the panel understand that the bar is very, very low, so it doesn't have to get much to get to a full claim. So if there's virtually nothing, then actually, well, we are going to go in that example, we are going to go to 75,000 anyway, despite the fact there's very, very little evidence. Yeah. I do appreciate, however, that when the letter comes out, it does look like you claimed £100,000, and because of the evidence, we're discounting you by 25%. I do appreciate that.
And if the chair will forgive me, just for moving from a question in relation to HSS back to the OC scheme, just to try and help in terms of the clarification of a question Ms. Page just asked, shortfalls which are not related to the shortfall that led to conviction are routinely claimed in the OC scheme.
Yeah.
And often, as Ms. Page said, then there is no documentation to support those shortfalls, but a similar process applies in relation to consideration of those shortfalls within the OC process, as we've just examined within the HSS.
That's my understanding.
Can I ask you about delay in HSS and one particular aspect of it, which is raised in the correspondence,
of course,
which is about there being significant delay with HSS, which you've acknowledged that there are occasions on which there is significant delay. And one of the aspects of that is cases going back to panel.
Yes.
Is the decision at the moment about cases going back to panel being taken essentially by Post Office rather than it being a joint decision between Post Office and the claimant?
I think that's a fair challenge, Mr Maloney. I think it has been a Post Office decision, and for good reasons in terms of consistency of outcomes, because as I described, I think yesterday, the independent panel have that moment when they opine, they recommend, and then they take that step back and say, right, how consistent is this and how fair is this? And if something does go back to panel, it's usually supported with new information, a different take, a different witness statement, etc., etc. So there's more information to consider. So to put it back into the same forum would seem logical and seem the right thing to do to maintain the independence and to maintain the consistency and the fair overview. However, as I articulated to Mr Hudgell the other day in my response to this letter you just showed, is I think Post Office should be more flexible about that now, and as not a result of delays, but all the schemes maturing in a way that could be now a choice of the legal representative and the client around whether or not they want that to go to panel or whether they prefer to have a mediation or a face-to-face.
Yeah. Because going back to panel does significantly increase legal costs, doesn't it?
Which are paid.
Oh, of course.
Yes.
But in terms of getting the money out there quickly,
yes,
as it were.
Yeah. I'm more concerned about the delay.
To get people into a room without there being additional legal costs, without there being the additional costs of the panel. Yeah. It may actually save money just to get people in the room and hammer out a result rather than going back to panel.
Yeah. I have to say I'm more concerned about the time it takes to get into panel and get out of panel. But yes, you're absolutely right. It would save legal costs.
Yeah. Just one other aspect of HSS costs, if I may. It's only recently that people have been able to secure treatment costs under HSS, isn't it? Mm-hmm.
Yes.
And that, whilst it was decided in June, was not essentially communicated until September of this year.
I'll take. Forgive me, I don't know, but you're usually very fact-based, Mr. Maloney.
Thank you very much for that, Mr. Ricaldi. There's been delay on that. Governance issues slowed that down in terms.
Yes. Yeah. Yes.
Is it unduly pessimistic to think that it might take another 2 years for all HSS decisions to work through at current rates?
Yes. I think it is unduly.
You think it is?
Yeah.
What do you think is a realistic time limit?
For all the dispute cases?
For the work, I think you've said there are 1,300, 1,400 cases left. How long do you think they're going to take?
Oh, for all of the
HSS cases.
So that depends on incoming, because so if you're talking about the current cohort, but we've got 30 coming in every day, and with the £75,000, which is an HSS case, with that live on the system and live in terms of mailing, we are expecting that the overall number to grow significantly. Yeah. Now, in terms of getting all that done, and we are optimistic in our forecast about how much of that will be the 75,000, and therefore we can automate as much as we can and be efficient around that. So it does depend on those numbers coming in, Mr. Maloney, and that is an unknown. But I think I shared with the inquiry the projections on the provisions, and that was pretty clear that we are expecting to use those provisions at least up to March 2026. So I can't give you. I'm afraid I can't give you a precise one because it depends how many come in.
So that's 18 months potentially, rather than 2 years.
But many of those cases we'll be dealing with will be new cases.
Of course, and you're getting about 30 a week in terms of new cases.
At the moment, we're getting about 30 a week. Yeah. But that's going to ramp up.
Isn't the reality, Mr. Ricaldi, that it's wholly dependent upon how many people take £75,000 quickly? if a lot of people decide that that's not enough, then we're still, I think Mr. Maloney may be underestimating in saying 2 years away from finishing.
You're right, it does depend on the take-up of the 75,000. I would say, Sewin, that other efficiencies that we're putting in place in the over 75,000 cohort will speed that up too.
No, I'm sure you're trying your best, Mr. Ricaldin, to be as efficient as possible. But the overwhelming feeling I get from your evidence is that a reasonably quick resolution of all cases in HSS is very dependent upon many people accepting £75,000.
Yes.
Right.
Just two very short matters to finish with, please, Mr. Ricaldin. You've explained that joint losses aren't available under the HSS scheme, and that's because the HSS is based on contractual relationships.
That's right.
And Miss Page asked you about this. That absence of compensation for joint losses stands in contrast to all the other schemes, doesn't it?
I appreciate that. Correct.
Yeah. Do you think that inconsistency needs to be addressed?
I think it will be discussed. I think it needs to be discussed. I don't know whether it will be addressed.
And finally, you mentioned culture at Post Office, and I just want to ask you one aspect about that. I'm not going to ask you to elaborate any further, but there was a serious data breach earlier this year when the GLO settlement deed was published online, and it included the personal details of those parties in the GLO, their names and addresses and so on. It did. Was that data breach a reflection of culture at Post Office in any way or not?
No, absolutely not. That was a genuine human error. And Post Office are so sorry that it happened. It shouldn't have happened. A process should have been in place that would pick that up. It was genuinely. It was an upgrade of the website, and the link to the GLO settlement agreement had broken, which was on the website. Just the link had broken, and they were refreshing that link. To refresh the link, they had to go and get the original document to put it there, and they picked the wrong one. I.e. they picked the unredacted as opposed to the redacted. And Post Office regret that, and we're very, very sorry for that. And you know we're in discussions with legal advisors about what we need to do about that. And it was very regrettable, and absolute apologies for that. It was just a human error. They picked the wrong document.
That's all I ask, sir, and thank you.
That's fine, thank you. There are just a few more questions from me, I'm sorry, Mr. Blake. And this is to make sure that I have no misunderstandings about things that are swirling around in my head and concerning me. Let's start with HSS. As of today, a new applicant can opt to accept £75,000, yeah?
Correct.
What would I have to do, Wyn Williams, if I was an eligible applicant to HSS to get the £75,000?
So you would either pick up your post where with all the application form in and explanatory notes, or you would go to the website and you would fill in the form. And if you believe that you want to accept the 75,000 offer, then there is a shorter version, there is a short form, and you only have to fill in the first number of questions, and then you don't have to fill in anything else. You send that in, and then, providing it's proved to be an eligible case, you will get an offer of 75,000. You sign the offer, and you'll be paid within 10 working days.
Right. If Wyn Williams had been a bit quicker off the mark, and had submitted an application a month before the £75,000 offer scheme came into existence, I would have submitted different information to the Post Office. Yeah.
you would have submitted the same information but more.
Yeah. At the point in time when the £75,000 offer came into being, would I, in those circumstances, be able to say, right, stop, I'm very happy to take £75,000?
Yes.
And that would be by me just writing you a letter saying that, or
No,
what?
so if your claim, with all the questions answered, if your claim is in the process today,
Yeah,
you will actually get a letter to say, we've got your claim
yeah.
here, but would you prefer to have this £75,000? And so
And I could say yes.
you will be approached to win.
Yeah, right, fine. In fact, I was one of the earlier people to make an application. And so I had accepted £53,000, all right?
And you settled to win?
Yeah. And so I assume I get a letter saying in due course, you get another, if my maths is right, £18,000.
You do indeed, Mr. Sewin. That's exactly what happens.
And then I could accept that. And that would be true whether it was £53,000 that I'd accepted or £2,000. I'm entitled to the difference.
Or anything in between, indeed.
Yes, exactly, right. One further variation on that, I have filled in the form. I'm now back in making an application post the offer of £75,000 being announced. So I'm filled in the form, and at that point in time, I decide £75,000 isn't enough. I'm entitled to much more. So I fill in that part of the form. I don't ask for the 75,000.
Yeah. So
Can I change my mind?
you would complete the entire form as opposed to just part of the form, and
because I think my claim is worth 150,000.
yeah, and you would make it clear.
As time is going along, I get fed up with it all. Can I change my mind?
So yes. So if you then get fed up, so your claim is in for 150 and it's being processed, as part of the process anyway, you will still, even though your claim is for 150, you will still get a letter from Post Office saying, we know your claim's for 150, but actually there is this opportunity of 75,000. Do you want to take it or not?
Yeah.
So that will still be an offer to you, made available to you, even if your claim is for over 75.
And does that offer to me remain open right up until you actually assess my claim?
No, it doesn't. You have to take again. It's for settlements to win. So if you're not going to accept the 75, and the jeopardy you face is your claim goes into panel at 150, and it comes out at 50.
And then that's it.
That's it. You get 50.
And in between my decision to go for 150 and the actual offer, I can't change my mind in reality, can I?
Well, and unless you again, in part of the process is, yes, you've applied for 150, but here's your opportunity to take 75. Do you want to take it? You say, no, I don't. Fine, your 150 will continue in the process.
Yeah, sure. But I can't say I don't want to take £75,000 on the day I fill in the forms, but say 6 months later, because I'm frustrated with the process, I say, okay, I'll take the 75. That opportunity is gone.
You can intercept that. Again, even though you've submitted 150, you will get a letter to saying, yes, you've submitted 150, but do you want to take? So that is in the process.
Yeah, but it's
if you reject that, you're right.
At the beginning of the process.
Yeah.
But once I say, no, I'm carrying on with it, then that's it.
Correct.
So in that sense, it's the same as the overturned convictions process, where once you go down the road of trying to get more than 600, you are stuck with whatever you ultimately get.
To Mr Maloney's point, yes.
Yeah, the two are the same
Yes.
in that sense. Right.
The jeopardy is there, yes.
And it's the same jeopardy in both schemes,
Correct.
which is what I was concerned about.
Correct.
Okay, thank you very much, Mr. Ricaldi. Is that it, Mr. Blake?
It is, yes, sir.
Fine.
Can we
Thank you.
take a 5-minute break before Miss Munby comes into the room?
Of course I'll do that, but first I'd like to thank Mr. Ricaldin for giving evidence over a considerable period of time about issues which are very close to the heart of very many people. So thank you very much, Mr. Ricaldin, for your written and oral evidence to this inquiry.
Suin, can I take the opportunity of saying one very short statement, please?
Of course, yeah.
I'm just very, very conscious for the inquiry that my statements, my latest statements of 6, 7 and 8, get that right, 6, 7 and 8, are hugely number-based, and the questions I was asked was about trends. I hope I've helped the inquiry with their cogitations on it. In terms of that. But what I would like to say, the same as I basically said to the Select Committee on Friday, and this is not contrite in any way, please, is I'm very, very conscious that it's all about numbers. How many, and I've been asked questions about numbers, how many, how long. Behind every number there's a person, and there's a person who's been taken on a journey, and that journey is not a great journey. And I would like to take this opportunity again to apologise to all the postmasters and postmistresses who've had to experience that journey, not just about the event itself in terms of the shortfall, but obviously that, but the journey that Post Office have taken everybody through, which is not a great journey, and it's something that we really need to learn from, because it's not a great experience. And quite frankly, the way these people have been managed and handled is a disgrace. And we should make sure that this never, ever happens again.
All right, thank you very much, Mr. Ricaldin. So we'll now have a few minutes break. I won't wander away, so to speak. I'll just wait here, Mr. Blake, and then when you're ready, in about 5 minutes, we'll reconnect, all right?
Thank you very much, sir.
Good afternoon, sir. Can you see and hear me?
Yes, I can, thank you.
We're hearing from Miss Munby.
Yeah.
Stand up. If you'd like to repeat after me, I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Please can you state your full name?
Sarah Ann Munby.
Ms Munby, thank you very much for attending the inquiry today to give oral evidence, and thank you for producing 2 written statements to which I now would like to turn. They should be in a bundle of documents in front of you. Could I ask you please to turn your first witness statement up? And do you see it 23rd of September 2024?
Yes.
For the record, the first statement is reference number WITN 1152010. Please could I ask you to turn to page 24 of that statement. Do you see your signature?
I do.
Is that your signature?
It is.
Now can I ask you please to turn to your second witness statement dated the 2nd of October 2024. Again, for the record, the URN is WITN 1152020. And please could I ask you to turn to page 35. Do you see your signature?
I do.
And are the contents of those statements true to the best of your knowledge and belief?
Yes, they are.
Thank you, Ms Munby. Those statements now stand as your evidence to this inquiry. They will be uploaded onto the website, the inquiry's website, I should say, shortly. I'm going to ask you a few questions about some parts of those statements now. And I'll start with your background, please. You joined the Department of Business Enterprise, Business Enterprise and Regulatory Reform in July 2019.
At that time, it was the Department for Business, Energy and Industrial Strategy, but yes, in principle, that's exactly right.
Predecessor department. And you'd spent 15 years at that point as a managing consultant.
That's right.
Your first role at the department in 2019 was as Director General.
That's right.
What was your area of responsibility as Director General?
The job title was Director General Business Sectors, and it was primarily a business-facing role, looking after the major sectors of the economy that BEIS then had responsibility for, including the car industry, steel, life sciences, and various others. At that time, I would say the primary focus of that role was on working with business on the issues related to EU exit, and particularly the possibility of a no-deal exit. That was probably the sort of single overriding priority of that group of people within the department at that time.
To what extent, when you were a Director General, were you involved in postal affairs?
Not very much. You'll see from various of the documents that I was copied in and kept informed, so I knew what was happening. But at that point, the sort of channel of decision-making and advice was primarily running through Carl Cresswell, the director, up to Alex Chisholm, who was the then permanent secretary. When Alex Chisholm moved on and Sam Beckett became the acting permanent secretary, I stepped up my involvement to make sure that there was the right level of senior cover. But prior to that, I think it's fair to say that Alex had been involved in it for some time. It was obviously a really serious priority issue for the department. I was new both to the department and the civil service, and so he was taking kind of primary carriage of that issue. I was kept informed, but I think you'll see from the record, I wasn't an active player on the scene, really, until that point that Alex left the department.
You were appointed permanent secretary to the department in July 2020.
That's right.
And you remained there until the 6th of February 2023, when you moved to the Department for Science, Innovation and Technology, again as permanent secretary.
That's right. That was the point at which BEIS, the then department, ceased to exist.
I want to start by looking at the department's oversight of Post Office. Please could we look at your second statement, page 12, paragraph 24. You say, historically, I understand from the record, there had been serious inadequacies in His Majesty's Government's oversight of Post Office. Pausing there, what are the serious inadequacies you're referring to in this paragraph?
Well, I think it's, first of all, important to say that, clearly a terrible, horrific miscarriage of justice had occurred, and regardless of what the arrangements had or hadn't been at that time, I think it would be reasonable to say that it's almost sort of goes without saying that there must have been some serious inadequacies in order for that to have taken place. But specifically, I know there had been a kind of series of conversations to which I wasn't party. I only know this sort of from the later record about the extent to which UKGI were able to access senior officials within the department, and that Carl Cresswell's team had been created as a policy team within BEIS in order to, A, make sure, frankly, that there was broader and deeper oversight, and B, to make sure that that connection between the activities of UKGI and the department was much stronger. And that team was sort of in place and functioning by the time I joined the department.
So you go on to say, immediately after that sentence, about the dedicated Post Office policy team which had been created in the department. As you say, that was established before you joined as Director General. How do you say that the establishment of the policy team assisted the department with its oversight responsibilities of Post Office?
Well, there was a distinction between the primary role of the UKGI shareholder team and the policy team. I'd characterise it in a couple of ways. The first is that UKGI were focused on, I suppose, the issues as they relate to sort of looking at the Post Office itself. Governance, quality of the board, quality of management, financial performance, risk management, that sort of set of corporate governance issues. And the policy team had a broader remit, which you might say is sort of looking outward at the issues as they related to the Post Office, including the policy framework set by government, the relationship between government, not just BEIS, because of course Post Office was providing services to many other departments as well, that relationship between the Post Office and government. They did a lot of the work on securing financial approvals, both within the department and more broadly within government from the Treasury. And I think the second distinction I would draw is just, and this is true in general, where you have UKGI and a policy team in the department, or indeed any other department in government. I draw a sort of distinction in personnel as well. So what you've got inside UKGI are typically people who are involved in multiple corporate governance situations, who might be sitting on multiple boards, supported in a community that's made up of people who do that kind of work. The policy team, by contrast, would be made up of what civil servants would recognise as sort of fairly kind of mainstream policy colleagues who have sort of spent most of their career thinking about how you deal with ministers, what are the parliamentary considerations, all of a sort of set of issues like that. And so I think that's just the other thing to note, as well as having different areas of focus. I would characterise those two teams as having a kind of different backgrounds and skill sets. And that's not particularly commenting on the individuals involved. It's more of a general point about the sorts of skills and capabilities that you would look for from UKGI as a permanent secretary versus those that you would look for from your departmental policy team.
And again, how is that split, as you described it, assist with improving oversight of Post Office itself?
I think probably in part by addressing the weakness that I was talking about earlier, i.e. the extent to which UKGI colleagues, who were obviously closely involved in events at the Post Office, were able to sort of access ministers and senior officials within the department. And the second is, frankly, it's a set of people who are focused on where are ministers on this, where is Parliament on this, what's the broader context. And that isn't directly about kind of specifically governance of the Post Office, but I do think it's really important contextual work that you would want to have in place as part of your overall system of oversight.
Could we please look at UKGI 3011874, please? See, it's a document dated the 31st of October 2019, base partner organisation, governance and sponsorship, Post Office. And we don't need to turn it up, but at page 23, you are listed in the distribution list for this document. Would you have read this at the time it was issued?
Yes, I would assume so.
Could we turn, please, to page 3. We have an executive summary of this document. It says, opinion, some improvements are required to enhance the adequacy and effectiveness of the framework of governance, risk management and control. Is this referring to the department's, effectively the department's oversight of Post Office itself?
I think that's right, yes.
And we see there are a series of bullet points at the bottom, the first of which says, well, no, let's look at the head before that. In the context of improving existing sponsorship and shareholder activities, we have identified the following areas for improvement, for which corresponding recommendations have been made in the action plan in this report. 1, improving communication links between the Post Office policy team, pausing there, is that the team you were just describing in distinction from the UKGI team?
Yes, that would be the team led by Carl Cresswell.
And the base partnerships team. What is the base partnerships team?
The base partnerships team was a team that sat at the centre of the department, responsible for looking not specifically at our relationship with the Post Office, but more broadly at the structures and capabilities across BAYS for dealing with what we referred to in BAYS as partner organisations, but you would more normally see referred to as ALBs. So in effect, it's a sort of centre of excellence for ALB management and governance. So what they're commenting on here is the extent to which the Post Office policy team is engaging with that departmental internal central team who are looking at how we look at the Post Office, but also UKRI, the Met Office, Companies House, etc., etc., etc. There were around 40 such organisations that central team would have been looking at.
So, I mean, some of the companies you referred to there, or public corporations, were also assets that were overseen by UKGI.
Yes, some also had UKGI involvement, some didn't. Among that 40 group.
It says discussions between the policy team and the partnerships team are infrequent, with no regular engagement around performance, risks, issues or concerns. This could result in risks or opportunities to share good practice being missed, negatively impacting Post Office's operations or BASE's oversight of Post Office. Do you know what, if any, steps were taken to address this point?
I don't remember specifically, but typically, I mean, this was an internal audit report. So we would have taken a series of actions around it and then tracked them through. I think it's perhaps useful to say that although, this is absolutely a point that was, raised by internal audit and something that, I would have wanted us to address, and I would assume that we did, I wouldn't put this point on a kind of enormously serious level, because what we're discussing here isn't, for example, the extent to which the Post Office policy team were engaged with the Post Office, or the extent to which they were engaged with UKGI. What we're really talking about here, I suspect, is a Post Office team who are dealing with quite a unique asset. Doesn't have that much in common with the majority of the other ALBs that BAs were looking after, and has its own very serious and specific issues at this time. So I can imagine it seems plausible that the Post Office policy team weren't making it their top priority to engage with that central partnerships team within the department. And although that would be something you would want to improve, I wouldn't have seen that as a sort of critical failure point. And indeed, I think that's reflected in the yellow RAG rating assigned here.
If we turn the page, please, there's a bullet point, first one on the screen, providing greater visibility of Post Office risks within BAs. The BAs policy team does not have oversight of risk management activities conducted within Post Office and or concerning Post Office by UKGI or the BAs partnership teams. This could impact the department's ability to influence/oversee the mitigating actions in place to ensure risks are aligned to their risk appetite and the quality of risk reporting to the permanent secretary. Would you agree that seems a more significant concern?
Yes, absolutely.
What steps, if any, were taken to address that point following the issuance of this document?
I think it's probably makes sense to sort of put this in context of wider work that was going on to improve risk management in the department at the time, including then when I was permanent secretary. I mean, this feature that you're seeing here of, an insufficiently clear risk escalation process, which is sort of one way of describing what you're seeing here, I don't think was a specific Post Office issue. Actually, there was just more maturity needed around risk. Later, we, for example, created a new implementation directorate with new SCS roles who were responsible for improving this system. It was something that I as permanent secretary worked on.
What system?
The risk reporting system.
Right.
As in, how do you make sure that when a risk has been identified in one place in the organisation, it's cascaded up through a directorate level risk register to a group, i.e. Director General level risk register, and into the departmental risk register. If I may just make one comment, I do not think that at this point there was any lack of visibility of the risks around the Post Office for the permanent secretary. It was one of the areas of the department that the then permanent secretary was very highly personally involved in. So I think it is absolutely an important sort of process point to address in the context of the quality of risk reporting in the department. But do I think at this time there was any danger that there was sort of invisible, unknown risks surrounding the Post Office specifically as it related to the permanent secretary? I would not have been concerned about that at the time, given the frequency of interactions and the level of personal attention that was being paid to these issues. That doesn't mean this isn't something that needs looking at, but I would see it more as a kind of a challenge to the maturity of the risk processes rather than a kind of a danger to Post Office oversight specifically.
On that, we've seen plenty of evidence of the approach to Post Office following the Common Issues judgment and the involvement of the department in overseeing matters. It was a lot of time was spent on it. Looking forward, one of the things the inquiry is investigating is what systems are in place to ensure that risk is properly identified in the Post Office going forward. So are there systems in place in response to this document? And you said in your evidence then it needs looking at. my question is, has it been looked at, and what concrete steps have been put in place to ensure that risk is properly identified within the department now? Post office risks are properly visible within the department.
Well, if I may say so, referring to current state, that would be a question best put to the Permanent Secretary for the Department for Business and Trade. I can't comment on current state. I can only comment on what happened during my tenure, which I'm very happy to do. I just wanted to clarify that.
Well, let's limit it to waiting by the time you left the department.
I am struggling to recall in detail. I'm sorry, I wasn't particularly prepared for this line of questioning, and I'm happy to go back and look at the documents. I can't remember exactly in detail what the kind of process forms were by which the risk process went through. But by that point, we had in place directorate level, DG level risk registers. We had principal risks at a departmental level, and we had a team responsible for oversight of that overall system. And I would certainly expect that the risks involving the post office would be kind of flowed through that. We, of course, also had an audit and risk committee within the department. I know that they spent quite some considerable time going around arm's length bodies, including the post office. I forget the exact details, but I think there were occasions where the chair of the Bays, Arak, was involved in risk discussions at the post office. I'd have to check the record on the detail. So I would say it was a reasonably effective risk management framework. My experience of risk management in the civil service has been that given the diversity of risks that you are dealing with, it's quite difficult to establish what I would call a really best practice risk management framework, just worth noting. UKGI, of course, also has its own risk management approach, and you also see post office risks tracked there. I just thought that was worth mentioning.
Yes. Move on to another point you raised at 24, paragraph 24. It doesn't need to come up on the screen. I'll read it to you. One of the points you say about, you say there's been serious inadequacies in the oversight of Paul, Post Office, by the time he took over. I do think much of this has been addressed. And one of the points you make is we had a minister leading on postal affairs, spending very significant time on the Post Office, who, for example, met monthly with the CEO. Can I just clarify that? Was there a change in the minister's portfolio at that time to enable the minister to spend more time on Post Office, or was it just that he or she chose to do so at the time?
I'm not completely sure about that, because I think that change. I don't know if there was a change that sort of predated my involvement. What I can say with confidence is that for Paul Scully, who was the minister for the majority of this period, Post Office was, just to give you some examples, when I would have a regular catch-up with him, it would always be sort of the first point on the agenda. I saw from sort of the flow of submissions and responses that it was something that was getting very serious ministerial attention. I think I have heard, but I wasn't able to kind of put together a record to demonstrate this from the papers that DBT were able to supply. I think I have heard that the portfolio had shrunk at that point, but the change clearly wasn't really significant. Otherwise, you would sort of see it in the public portfolios very straightforwardly, and I couldn't quite pick it up when I tried to check the record on this point. So I'm not sure I could say that with confidence, but I did not perceive during my time as Permanent Secretary that we had a problem with a lack of ministerial sort of time or energy on the Post Office. Others, of course, may have a different view, but I didn't see that problem.
So I know it's we've only just started, but I'm moving on to another topic, so I wonder if it's a good time to break for lunch there.
Yeah, by all means. 2 o'clock, all right?
Yes, sir. Thank you.
Bye.
Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Could we please bring up the second witness statement at page 13, paragraph 26? You're discussing governance arrangements at this point of your statement. And at paragraph 26, you say, I think the hard part tended to be actually getting Post Office to do what ministers wanted. As described above, the department did, from 2020, have a power to issue directions to Post Office, but ministers could not routinely become involved in the nuts and bolts of operational decision-making. And at paragraph 27, you give an example of this in managing legal costs, which we'll come back to. But if we could go over the page to the bottom of paragraph 27. You say, for these kinds of important but ultimately operational matters, if Post Office did not do as we asked, we had relatively few levers with teeth other than the ones that had other issues, brackets, like removing the chair or pushing the organisation into financial trouble. Did you experience similar problems with other ALBs, namely finding it hard to get the ALB to do what the minister wanted whilst you were permanent secretary?
I'm just sort of testing my mind for examples. Yes, I think is the right answer to that. It varies according to the structure of the arm's length bodies, and an example like Post Office is sort of quite arm's length. So there'll be other examples like executive agencies where you might have, you know, much more explicit clearances over salaries within the organisation, for example. But the idea that, you know, like in many situations where you're in a supervisory or a management function over somebody or another organisation, although you may have a sort of set of formal levers at your disposal, often sort of your first port of call is influencing. You know, it's a bit like if you're managing an employee. You might ultimately have the ability to terminate them, but that's a really drastic step and one that you wouldn't take until you've gone through talking to them about why you want them to do what you want them to do, hearing what they think about it, trying to give them some training, increase their capability. You know, I think it's a very common journey, and I certainly saw it with other arm's length bodies as well. I do think it's particularly acute in this case because the combination of being at the more extreme end, like a long arm, if that makes sense, in the context of the Post Office, combined with being so troubled and having rightly so much political attention on it, I think that's a really difficult combination. Whereas if you took a body, if I compared it to something like the Ordnance Survey, just to take an example, you'd have a similar set of levers and a similar degree of arm's lengthness, but just a much lower level of heat, at least during this period, around the organisation and its performance. So I think that's why it sort of comes quite acutely in the case of Post Office, because you're combining a long arm with a very great deal of legitimate political interest.
Reflecting on matters, have you thought, or can you assist us with whether there are any other levers that would assist in managing Post Office in this way?
It's a good question. It's maybe worth just reflecting for a minute on, you might say if we had the ability to make directions, why isn't that sufficient? I mean, that's actually quite a strong lever, right? That's effectively creating a capability for the Secretary of State to say, Post Office, you must do X. And I think the reason that has tended not to be that relevant is there aren't that many decisions in a complex organisation like the Post Office that are sort of really like simple and binary. You know, should I X or should I Y? it's often much more complex. So if it comes to something isolated and specific, a sort of direction power where you can say you must X works well. And I think that direction power came about in response to the events that surrounded earlier handling of the litigation, where there were some quite specific questions, including the one about recusal of a judge. I'm not over all of the detail, but those sorts of matters, it kind of, you can imagine a department being able to say to an arm's length body, you must X, therefore X. But something like reduce your legal costs, which is the example I use in my witness statement, it's much more of a sort of debatable point, because the Post Office, not illegitimately, would want to come back and say, well, we need these legal costs for reasons X, Y, Z. We are going to reduce them, but not until next year, because the contract needs to come up for renewal, et cetera, et cetera, et cetera. So it's much more of a dialogue about what is and isn't reasonable, rather than a sort of, you can order people to do things. That tends to be oversimplistic for what we're talking about here, which is why actually the influence, the presence on the board matters, being part of the discussion, understanding the nuance and the detail. So I think I find it quite hard to answer your question with a really specific, like, if only we had power X, we would be able to make everything okay. I don't think it's like that. I think it's more like having a strong, productive relationship with respect on both sides, and listening to each other has got to be the right starting point. And I don't think the formal arrangements that we had during this period precluded that.
I want to look at one example, please. Could we look... well, we don't need to bring it up, actually. You refer to the review of Tim Parker's decision not to share the SWIFT report. That's, for the record, paragraph 18 of your statement. You describe it as a governance failure. And you say, after learning of this and giving consideration to whether we should advise ministers to fire Mr. Parker, formal censure was chosen as the appropriate course of action. Was a minister involved in the decision to censure Mr. Parker rather than terminate his contract?
Yes. That decision would ultimately have gone to, I know for sure it went to Paul Scully, the minister. I don't recall specifically whether it went to Secretary of State. It may not have. It may have been a delegated decision, but that was signed off by ministers. But as I do say, just for the sake of clarity, I do say in my statement that was on our advice, and our advice was formal censure. So you might, I wouldn't wish to sort of put it only on ministers, but yes, of course, any decision like that would be signed off by ministers.
Could we look, please, at poll 200104-180? This is your letter to Tim Parker after that decision was made on the 7th of October 2020. The second paragraph, please. Thank you. You refer to the background to that, which is well known. And towards the end, you say, we consider it was a mistake not to have ensured that the whole board had an opportunity to see and discuss the detail of its findings and agree what any next step should be. With hindsight, this information should have been seen by the board, and we are disappointed that it wasn't. And you go on to say matters about sharing documents said to be legally privileged. Firstly, why did you say with hindsight this information should have been seen by the board?
I think it's sort of felicitous drafting. I'm not sure there's any deep significance to with hindsight. I mean, had we been asked the question at the time in possession of the full data, one would have said the same thing at the time. If you or I was transported back to the moment where that decision was made with the report in front of us, I hope we would have decided that it should have gone to the board.
It might be said that this letter doesn't contain a sufficient degree of criticism or disapproval to be described as a formal censure. What would you say to that?
It's certainly one of the harshest letters, if not the harshest letter, I have ever written to a chair of an arm's length body I've been involved with, and I've been involved with a very great many arm's length bodies over some considerable period. So, opinion could differ, but I would say that as a matter of fact. It's fair to say that, I think as I say in my witness statement, as I reflect on it now, I actually think the advice probably should have been to
we'll come to that
go further.
In a moment.
So I agree, in other words, that sort of looking at it now, you wonder why we didn't go further, and that could include either a sort of a harsher drafting or indeed a different decision altogether.
Was Mr. Parker told that dismissal had been considered as an option?
I couldn't say for sure.
I can come down, thank you. You just said there about what you say in your statement regarding whether that was the right decision. We don't need to bring it up, sir, but for your reference, it's paragraph 18, page 10 of the second statement. You say, with the benefit of hindsight, it was perhaps the wrong decision not to take the harsher course of action and terminate Mr. Parker's appointment. So again, you say with the benefit of hindsight. Have you learned anything since October 2020 that now makes you doubt the decision that was made?
Well, yes.
What did you
I mean,
learn?
I think probably lots of things fall into that category. So, first of all, I think all of us, at least on the HMG and post office management side, over time, the full depth of the scandal in the first place has been sort of further elucidated. So I'm not saying it, obviously at the time that this decision was made, we knew this had been a very serious error, but as the sort of the picture grows around it and you try to isolate, what were the moments that could have made a difference? I think now I would see that moment where the Swift report wasn't shared as a relatively critical one in the story. At the time, I don't think that was as clear to me, simply because, I mean, I've obviously been following the inquiry closely and all of the events that have happened in HMG as well. That just wasn't as clear to me at that time. I don't think there's sort of one particular fact I've learned, but as just the picture becomes deeper and clearer, that looks like a critical moment. And I also think at the time, it was an in the balance decision that was considered both ways, if you see what I mean. And at the time, the advice of the SID was taken into account, and it was also kind of top of.
When you say SID, do you mean Chemical?
Yes, I'm sorry, the Senior Independent Director Chemical. Thank you. It was also kind of the decision in the round was taken in recognition of the fact that switching people out causes instability, and that there would have been all sorts of challenges with trying to get another chair at that time. And I guess that felt like a very important issue in the moment. And now when you look back at the picture overall, on lots of cases here, I think you ask, should people have been bolder in making changes? And this, I think, therefore, I probably see it with that perspective now.
At the time, Ms. Munby, were there senior people who were consulted about the issue who actually favoured terminating the chair? Or was it more or less a unanimous view that censure was appropriate?
I don't remember anybody sort of specifically pushing, but it was certainly a decision on which many of us, myself included, felt was very much in the balance, if that makes sense. I don't think there was sort of there wasn't like a censure side and a termination side and we were having a face-off. It was more like a debated issue that we were discussing as a senior team what we thought was best, and this was where we landed.
Okay, thanks.
At the time, were you involved in any oversight of or investigation of whether officials within the department had knowledge of the Swift review?
No, or not that I remember.
do you think such an investigation should have been carried out?
Possibly. I don't remember enough of the facts surrounding the case to give you a really confident answer on that, if I'm honest.
I want to turn now to look at some of the compensation schemes. I'm going to deal with this at a relatively high level because we've heard evidence from Simon Ricaldin and Carl Creswell will be giving evidence on the issue later this week. In your statement, is it fair to say a common theme that you point to as the reason for the alleged or the delays in compensation is what you describe as an underestimation initially of the scale and depth of the challenge in providing redress to postmasters?
Yes.
I want to begin by looking at the effect of managing public money on compensation schemes, please. Could we bring up poll 20413-475? So this is Managing Public Money, the May 2021 edition, and would you agree a fair summary of this is that it sets out the main principles for dealing with financial resources in the public sector?
Yes.
And during your time as Permanent Secretary, the Chief Executive of Post Office was an accounting officer for Post Office.
Yes, it's a little bit more complicated than that because you have a structure where you have a principal accounting officer at the departmental level, and then depending on the nature of the status of an arm's length body, the CEO may be an accounting officer in their own right. I think it might be the case in Pol specifically that they're more correctly described as an accountable officer, but which is I think a technicality, but it is of course fair to say that what's in here would represent principles that the CEO of the Post Office should have in mind.
And as Permanent Secretary and Principal Accounting Officer for the department, your responsibility was to make sure there were arrangements in place to satisfy yourself that Post Office had systems adequate to meet the standards required of managing public money.
Yes, insofar as they applied to any particular aspect of the Post Office's operations,
yes.
Because obviously much of the money that Post Office was dealing with wasn't quite correctly described as public money.
Could we look, please, at page 20? Paragraph 3.3 says there are several other areas where accounting officers should take personal responsibility. And at points 1 and 3, we see regularity and propriety and value for money. And in your in the documents that we'll go to, it's fair, isn't it, that regularity and propriety and value for money are concepts that were applied to the establishment of the various compensation schemes.
If I may, there are 4 core concepts that underpin any accounting officer test, as I would put, on any new announcement that the department was making. Those are regularity, propriety, value for money, and feasibility. And any major new initiative by the department needs to be assessed against each of those 4 criteria and needs to have personal sign-off from the accounting officer before it can be launched.
So I think, subject to you adding feasibility, the answer to my question was yes.
Yes, I mean, I guess I'm saying yes, very, very much so.
If we turn, please, to page 15. In box 2.4, just slightly down, we have a description of regularity. It says regularity, complying with the relevant legislation and wider legal principles such as subsidy control and procurement law, delegated authorities, and following the guidance in this document. When we're considering compensation schemes, does regularity apply apply in the sense that the question is whether or not there's legal authority to make compensation payments themselves, or does it also apply to whether any compensation payment that is made must itself be justifiable in legal terms?
I don't think it follows from the principles of regularity that you can only compensate people to the extent of your legal obligation. And indeed, I'm sure you know that, within the sort of framework for initially the HSS, the sort of core documents of the scheme were about trying to offer fair compensation, even insofar as that went above what was sort of a strictly legal obligation. And I have certainly never understood regularity to mean that. Where regularity has been very relevant in the context of the post office, where this test has been particularly live, is actually where you're talking about payments from the department to the post office, and then from the post office to members of the GLO class, where the question of under what parliamentary authority were we making those payments, this is probably well known to the inquiry, was very, very kind of extensively explored. That would be a regularity issue. Is the expenditure regular? Is it properly sort of sponsored by Parliament? I have never made any comment, I don't think, on regularity in the context of individual compensation payments. And the reason for that is ultimately the accounting officer requirements come second to the question of whether the policy intent of the minister is being fulfilled. So, you're asking the question, the compensation needs to be full and fair, and then we need to find a way of making it regular. You don't say, I'm going to use regularity as a way of not making it full and fair. And so if ministers think that fair goes beyond legal liability, and ultimately that's the sort of question that is for ministers, then the only regularity question is whether we have a piece of parliamentary authority that we can use to make those payments. You would never use regularity to sort of undermine that ministerial perspective.
Just out of that point, how does the value for money aspect of managing public money fit in the scheme in the context of compensation schemes?
So basically the same point. It's worth mentioning there's, at least in the latest edition of Managing Public Money, there's quite explicit reference to compensation schemes, in which in effect it says the same processes apply in compensation schemes. They're like any other form of public money expenditure, and value for money, regularity, etc., apply. Again, value for money is always about value for money for a given ministerial objective. So it's not like you have to justify, is it value for money to deliver full and fair compensation? The requirement is to deliver full and fair compensation. The question that an accounting officer would be asking themselves, and I did ask myself, is, are we delivering that full and fair compensation in a value for money way? And there's probably a few aspects that come up there. Firstly, and very obviously, are the procedural arrangements for running the scheme good value for money? And normally you would want those costs to be as low as possible, although clearly that's not an absolute rule because, being slow also adds cost. The second thing you would usually have top of mind when you're thinking about a scheme like this is the area of fraud and error. That's been a really substantial problem in a lot of government schemes. In this case, I want to be clear, I'm not suggesting that there was any fraud in any claims made, but you would, for example, want to be confident that you weren't making payments to people who weren't postmasters, would be a good example. An error is another very common characteristic. That would be particularly things like where you make the same payment twice. So you don't have sufficiently good record keeping and you pay out a grant and then you make the same grant again to the same person without realising. That would be an example of error. And again, that would be, regardless of what sort of scheme you were looking at, that would be top of your mind as an accounting officer. I think with compensation schemes, it gets more complicated when you get to what level of compensation is value for money. And ultimately, the first place you look there is for what was the original policy intent. And in this case, that was for the compensation to be full and fair.
But is it fair to say that the value for money is relevant to the question of the amount of compensation that is paid? Namely, is there when considering value for money, does one have to consider whether compensation payments made are too generous or overly generous?
It would really depend on what the ministerial steer was. So let me give you an example. In this context, at the kind of early stages of HSS, and indeed for some time, this was not just a short-term thing, the sort of principle on which the payments were being made was that there should be fair compensation at an individual level, i.e. the amount of compensation that an individual received should relate directly to the injury and suffering that they had experienced as an individual. Once that's your policy intent, then yes, value for money principles would suggest that you should compensate people to that point and not further, except insofar as that was a sort of reasonable compromise in the grand scheme of things. Whereas, later, I know that the schemes have moved to much more sort of fixed offers that move away from the principle of sort of compensating according to individual level of loss. Once you've made that decision that that's your intent, then you would look at value for money from a different angle. So I guess you can't sort of discuss value for money in the abstract without understanding the goal that you're trying to achieve. But once you have specified that goal, and once you have specified a principle like you're compensating on a kind of an individual basis, then yes, of course, you would expect value for money to be relevant, just as it is, I should say, in absolutely every other aspect of any government money spent anywhere.
Can we look, please, at UKGI 30018879? And if you could go to page 2, please. We see this in an email from you on the 30th of June 2020, and it says the subject is for comment close, Post Office convicted Postmasters compensation scheme. And you say, one point of clarification from me, does the establishment of the compensation scheme prevent the malicious prosecution claims, i.e. can it actually close off the risk of larger sums materialising in any case? Is it that we expect claimants to prefer a cheaper / less risky route, even if for a lower benefit? If so, how sure are we that will be true? What was the purpose of your questions at that point? Why did you seek those answers?
I hope this won't seem like a cheap answer. I mean, because I was seeking to understand. So this is very early on in my engagement with this scheme. I've just been given a piece of advice. I actually remember, interestingly, not getting factually whether it was the case that by running a scheme you sort of close off the legal route or don't. And that seemed to me an important point. I wasn't pushing a particular point of view here. I was genuinely just seeking to clarify the situation and to understand better. It's quite a large, it's a significant piece of policy work, significant money associated, and I felt I should understand what was going on. You'll see later I get a reply and I say, sounds good, go ahead. Well, I didn't have an agenda.
I'm going to come to that reply now, please. Can we look at the bottom of page 1? We see an email from, sorry, I've gone a bit too far. It's an email from Tom Cooper, 1st of July 2020. It says that it won't prevent claimants from pursuing a malicious prosecution claim. but goes on to say, the point is to provide a quicker and cheaper route to redress compensation than having to go through the courts again. This is in the interest of all parties, of course, claimants, Post Office and His Majesty's Government. To your last point, we would always expect claimants to take some discount to the full potential value of a malicious prosecution claim because, one, the outcome will be inherently uncertain as in any litigation. Two, it will take a very long time, particularly if there are appeals. And three, it will involve substantial costs which some or claimants may have to fund externally and for which they will end up having to give up a large share of the proceeds if they win. Is it fair to say that at this point, one of the policies behind the schemes was to seek to settle the claims at a value less than they may have been at trial?
Yes, although I would caveat that by saying I don't think the sort of overriding consideration was to settle the claims at a value less than they would have received at trial. It was that settlement is, I mean, generally, I think, lawyers might disagree, but generally a better approach for all parties. So I would just, I don't think that's to negate what you just said, but I just think it was more that context than a sort of, financial minimisation as the core motivating factor.
Could we look, please, at base 40961, please? It's an email on the 8th of September referring to a meeting the day before. We see there are attendees from Post Office, including Nick Reed and Tim Parker, and you are listed there as Perm Secretary. Could we go to page 2, please, for part of the readout? And it says, Tom noted that although Alan has taken the thinking on this quite a way, Tom is keen that BASE/UKGI don't get too involved in the detail of the schemes, but focus more on the communication side of things. Pausing there, was that an accepted position within BASE at that time, in September 2020?
I'm not sure.
Okay.
Sometime around this time, and I'm not sure I could put the chronology, was it exactly before this meeting or after this meeting, but this was during the period where we moved from sort of thinking this is mostly a Post Office thing to we really need to get across this in a very great deal of detail. And I'm just not sure I could put exactly where this fits in that chronology. Apologies.
Goes on to say, Carl asked whether Perm Sec, that's referring to you, had any views as accounting officer and ensuring propriety, VFM, I assume value for money, ethical considerations on any comms statement. Permanent Secretary wanted to know if the wording of the statement was consistent with only mediating on the cases that would come up. Can you help us with what that means?
I don't remember.
It says the Permanent Secretary noted that none of the schemes are terribly attractive. Why did you think none of the schemes were terribly attractive?
At that point, we were discussing a range of different options, all of which were expensive, all of which were onerous for everybody involved, government and postmasters, and it kind of being given a set of options to choose from about how we might approach compensation. There wasn't one that I looked at and thought, yeah, you know what, that's great. It was choosing between, difficult options, none of which were perfect.
I'm sorry to interrupt again, but can I be clear? At this point in time, I think we're in early July, are we, 2020?
This is September 2020, sir.
Right. So HSS has already launched. So presumably you're here talking about what to do with the people who are having their convictions quashed. Is that it?
That's right. I think there was a presentation at this meeting about various different approaches for dealing with what later became the OHC.
Yeah, fine. Thanks.
You go on to say, he says, Carl said that all options and entitled to in the statement suggest the government is committing to give more compensation to claimants than they would actually be receiving. Carl/PermSec noted that through mediation, some claimants will receive much less than they think they are entitled to. Again, can you recall precisely what your concern was here?
So I'm going more by reading the text and thinking what it probably meant rather than having an exact, precise recollection. But we were looking at a draft of a public statement, which is very normal at this stage. Like, what are you going to announce, basically? And here, this is, talking about making sure that the statement doesn't overpromise relative to what we're actually planning to do. And without having the statement draft in front of me, I'm not sure I could tell you exactly what the problem with the statement was. But what this looks to me like is a discussion where we're saying, look, the two need to match. If we're going to give this sort of like very forward-leaning statement, are we confident that what we're proposing, this mediation-driven process, are we confident that it actually delivers against it?
Could we move on slightly in the chronology, please, to UKGI 3043126. And page 5, please. If we go down slightly, please. So we apologies, I think I've got the no, that's right. So this is from Permanent Secretary. I assume that's your private office email address.
That's right.
Yeah. Just had a conversation with Joshua. Sarah has some concerns with the AO assessment, presumably accounting officer assessment.
That's right.
And isn't happy to clear yet. If you could go down, please. It has a high value for money risk, and we're not sure why. What we need is an assessment of this announcement, which leaves room to design a value for money scheme. And it goes on to say we need a clearer answer on why we are confident this won't lead to a regularity challenge. Can you recall what was driving your concerns in respect of your accounting officer assessment of the schemes at this time?
Yes, and with all due respect to those who wrote this particular piece of advice, what this feedback is me saying this advice is not good enough. So the advice I received at that time, just to take VFM as the example, had what an accounting officer normally does is takes those 4 tests I was talking about earlier and gives like a rating against each of them. And this piece of advice had a red rating against value for money. And you can't, as accounting officer, just let that pass by. If it has a red rating for value for money or one of the other tests, you need to engage. And ultimately, if you really thought it was a red rating for value for money, if that was your considered opinion after getting the best advice you could, then you would actually need to ask for ministerial direction. Now, I absolutely did not think that was the case here. And what I was asking for is for the team to come back with basically a more intelligent piece of advice. What they had done at the time is they'd said, we haven't designed all the details of this scheme yet. It's still quite uncertain. And so it feels risky. So we're putting a red for value for money. But what I was trying to point out is all we're doing is making one step forward. We're announcing the scheme. We're not tying ourselves down to an exact set of details. There's plenty of room within that to make sure that we do design a scheme that passes the accounting officer tests. And of course, that would be our intent, and that's what we would do. So I was asking him to go back and, basically create a piece of paper that, rather than saying this is all red and bad and you can't announce it, reflect the truth, which is this is fine from an accounting officer point of view, and it's perfectly ready to be announced, which was my view.
So we take this as a criticism of a draft rather than a substantive position on the managing public money assessment?
100%.
Please could we look at Bayes 40990? This is a briefing on the 10th of June 2021, so we're jumping ahead again in the chronology, and it's a briefing which we will come back to. You see, it's on the ownership of criminal convictions compensation, which regarding who runs that scheme. Could we please look at page 3, paragraph 12? Sorry, not paragraph 12. It's just a bit further down where it says efficiency. Thank you. So this is one of the pros, it says, of the government taking on direct ownership for compensation from Post Office. In either situation, we will need to scrutinise aspects of the compensation closely from a MPN, presumably managing public money perspective.
That's right.
This has caused Post Office some frustration in relation to the HSS scheme because of the process and conditions that we have had to mandate. Do you recall what Post Office's concerns were in relation to managing public money in relation to HSS?
I don't really remember them as being specifically about managing public money, but there had certainly been back and forth around governance and our involvement in the governance around HSS. I think by this point we had started putting pressure on around legal costs and administrative costs, which had been a very kind of tense set of discussions, and that certainly was a managing public money issue. I think if I had characterised what I knew at this point, I think I would have said more that they had sort of concerns or frustration from a governance perspective, maybe, rather than it being particularly an explicit dispute about managing public money. But clearly the drafting here suggests that. That was just be my perspective.
That document can come down, thank you. It's been suggested by some that the approach to the compensation schemes has been litigious or legalistic. Have you heard that criticism?
Yes.
Do you have sufficient knowledge of the operation of the schemes to have a view on that?
I think I do, although it's a partial one, and I'll just sort of say it as I see it. I think there's two aspects to this. And the first comes back to what I was talking about earlier, about taking a case-by-case approach to the schemes. And I mean, in my witness statement, I talked about sort of, if you went back, what might you do differently? And in a way, that original decision to have a scheme that was based on individual applications and assessments of individual applications, even if for a moment you put aside any concerns about how you do that, I'll come to those in a second, but just putting those aside, just inherently asking people who have been through something truly awful to go back over it as part of an application process has challenges, even if you do it in the absolute best possible way. So I think that's sort of point one. Point two then is actually particularly through the process here, I think there have been cases, but frankly, the inquiry would be as well placed to comment as I am. There have been places where you look back and you think, an individual case was handled not as generously as would be sort of properly viewed as compatible with full and fair. I don't think, certainly from my perspective, I never saw ministers or officials seek to achieve that outcome. And I didn't at the time see any evidence that the post office at a sort of corporate level was seeking to achieve that outcome. I think others are probably better placed to sort of say what happened on the ground and how it felt. But maybe a reflection would be that, you know, once you pass intent through a system, at the end, you might not always sort of feel the intent you started with, especially once you've gone down the, you know, perhaps necessary at the time, road of assessing each case individually. Because if you assess cases individually, it takes you down a path of wanting to see some level of evidence. And you can get into, and you may well wish to, discussions about like what the evidential bar is. But the difficulty with a system that assesses individual cases and has no bar whatsoever for evidence, if you have no requirement, is then it is 100% a matter of whatever is asked for, you will pay out without any process at all. And that is difficult from a managing public money point of view, because, of course, everybody would always like to receive more money. And if you don't ask for any evidence at all, it's really hard to know, are we compensating fairly, or are we starting to get to the point of, I don't mean sort of minor overcompensation, but, you know, really serious overcompensation based on claims that aren't right. And that I think that's a really difficult trade-off. And I do sort of wonder, looking back, you know, how easy really is it to design a scheme that looks case by case, but that doesn't end up feeling litigious to at least some of the participants in that scheme?
If we look at your statement, when I think you deal with some of those issues, it's your second statement, please, page 25. Page 25, yeah, it's paragraph 51. You refer to other approaches and the sort of application-based approach as it would necessarily have been much more blanket in its nature, and probably would have meant we all had to accept paying people whose circumstances were different the same amount as each other. Likely the only way it would be proved acceptable to postmasters is if the numbers had been in, so numbers had in general been much higher overall, levelling up. For His Majesty's government to have gone down this road, officials and ministers would have had to give up on two quite fundamental principles. First, fairness both as to between different applicants and as to between sub-postmasters and other victims of past injustices. And second, standard use of public money, as you would have had to accept making payments that could not, by any normal standard of judgment, be viewed as compatible with the formal guidance for spending taxpayer money or managing public money. Do we take from your evidence at the time, so putting ourselves back to September 2020 thereafter, that there wasn't a discussion on these more blanket approaches, which we've seen in post-2024?
I think I remember we were talking about that meeting earlier where there was you had the readout from it and you were asking me what things meant. As I remember, there were options in there that went to tranche-driven approaches, i.e. where you define a series of classes and then have kind of flat payments within class. I don't specifically recall, but it could have been. I don't specifically recall a proposal which was around kind of a single, very generous class, which is in effect what I'm describing here.
And so there wasn't the proposal you're describing here wasn't put forward to a
It's
minister?
not, yes, I think it's important to say it's not that lots of people were saying that this was what we should do, and I or somebody else came out and said, no, that isn't compatible with managing public money. I think it was almost perhaps taken as read that we would have a scheme that, broadly speaking, sought to provide as close as possible to full and fair to individuals. And you might have gone as far as a tranche-based approach, which obviously is not quite as precisely gradated as an individual approach, but is still gradated. I certainly don't remember an extensive debate. It may have come up once, I couldn't swear to that, but it certainly wasn't sort of extensively debated. And I certainly never said, you can't do that because of value for money reasons, because the question was never put to me in that way.
Looking back at that time, do you think sufficient consideration was paid to all the available options?
I mean, in one sense, the answer to that has to be no, because we're much further down the path, and you look at where the schemes are now, and knowing that that is where you're going to land, it is just undoubtedly irrefutably true that if that's where you're going to land, you would have been much better doing it earlier for everybody's sake, and particularly for postmasters. So in that sense, it was definitively wrong. However, if you go back and look at the environment that we were operating in at the time, being absolutely frank, I think if the proposals as they are now had been put on the table at that moment in their current form, but sort of put back into the historical context, I think we would have had insurmountable difficulties with HMT, the Treasury, with ministers, actually, and possibly, although it's always hard to answer this, possibly with me as an accounting officer. I think all of those sort of formal clearance moments would have been very, very difficult to get through. And so I don't think that kind of radicalism was properly contemplated at the time. And so the question I ask myself is what would have to have been true to get the system as a whole to operate in a more radical mode faster?
Well, what changed between then and now? In the sense of you've said if we know where we are now, it wouldn't have been possible back then. What do you think the key differences were between the two times?
I mean, ultimately and sort of operationally, the strength of the ministerial steer to address the problem in full, sort of, and I use these words sort of appropriately, but kind of at any cost.
And what caused that change in position?
That it wouldn't be for me to answer. It happened after my involvement, and I wasn't there.
Let's go to what you say. You talk about some of the reasons for the delay. If we could.
Before we do that, Mr. Stevens, just so I'm clear, what you mean by the now are things like having fixed offers of £600,000 for convicted people whose convictions have been quashed, or fixed payments of £75,000 for people in the HSS. That's the sort of thing that you mean in relation to the now, is it, Ms. Munby?
Yes, that's exactly right. So when I would add to that list, although it's not a VFM issue, but the other sort of kind of fundamental overturning of the initial principles would be the mass exoneration, which would be another example.
The ultimate step, if I can put it in that way.
Yeah.
But the steps to it were things like, in inverted commas, what might be considered, and I choose my words carefully, as realistic fixed payment type options for postmasters to take up if they didn't want to go through a process of individual assessment?
Yes, I think fixed payment and interim payment options were, of course, considered earlier, and indeed, at least in the case of interim payments, implemented earlier. So I think it's the combination of being fixed and also the relative scale of them. I think that it's that combination that it would have been hard. I think even if we had had an official who was pushing that agenda, I think they would have met obstacles in the system. I just want to be honest about that.
Yeah, so I don't mean this in any flip sense at all, but Mr. Ricaldin was talking about the journey that postmasters have been on. You're almost describing a journey that civil servants and politicians have been on in terms of trying to achieve full and fair compensation.
Yes, I think that's right, although, like you, I wouldn't compare the journeys in their challenge or emotional cost or anything else. But I think the thing I've reflected on is when you get to the end, you always look back and you think, well, why didn't we just do that to begin with? Because as I've said, if you know that's the destination, it's much better to get there quickly than more slowly. So the question really is, why not? What was it that meant that didn't happen? And I think there are probably a series of reasons to do with underestimating the scale of the challenge, which you mentioned, Mr. Stevens, earlier, but also a belief that the processes would go better than they actually did. A sort of an excessive, what now with hindsight is obvious was an excessively high level of faith. I don't mean in the post office's ability to run those operations, actually, because as I said in my witness statement, I think many of the challenges might have been similar even if they had been run in the department or by an independent body, but a sort of confidence that the application of sensible governance and processes would lead to the correct outcomes. And actually what we saw is that application of what looked, broadly speaking, from my point of view at the time, like quite sensible arrangements, there were quite a lot of errors made. There were points missed, be that around impact on benefits or insolvent businesses, points missed, errors made, and approaches that didn't work out in practice how they were originally envisaged. And I guess overall I would look back and say, too optimistic about how well the processes would get rolled out. And that's partly a critique of how they were rolled out, but it is in equal part a critique of the sort of optimism that can often plague us when we begin schemes of any kind. I don't just mean compensation schemes, a sort of confidence that things will be okay, whereas perhaps a more sceptical, pessimistic approach that said, look, this is going to run into an absolute whole load of really specific challenges and it's going to end up being slow and painful. We've got to cut to the chase quicker. That if I could sort of put myself back in my own shoes, I think that is the message that I would want to have given more.
Thank you. Sorry, Mr. Stevens.
No, not at all, sir. Could we please bring up page 23 of the second witness statement? Got a section there, HSS and the slow beginning, and at 47 you say, I add my own personal apology to the institutional apology that Post Office has already made for slow progress during the early part of the scheme's operation. Post Office and in turn His Majesty's Government had seriously underestimated the scale, complexity and cost of the problem, and consequently His Majesty's Government did not press Post Office hard enough and Post Office did not themselves set up a sufficiently robust operation at the start. So I think it's part of what you were referring to there. Could we go, please, to UKGI 30-13178. So just for your note, this document is the note for the meeting in September 2020 that we went to earlier, the briefing note, which
Clear.
sets out matters which would have been discussed at that meeting. Not the minutes, I should say, sorry, the briefing note.
Sorry, Mr. Stevens, can you repeat that?
Of course, this was earlier. We went to a meeting in September 2020, and you asked a question about the timing of it.
Can you just give me the reference to that, and then I can cross-reference it in my note?
Yes, of course. It is BEIS 40961.
Yeah, fine. I've got it. Thanks.
So if we go, please, to page 10. We see what was then the historical shortfall scheme, update 20th of August, updated version from 25th of August. Closure of the application window. The HSS application window officially closed on 14th of August, and it says that as of 25th August, 2013 claims have been received, amounting to around 100 million, being what's being claimed. So in your statement, you referred to the estimates in July 2020 as being 500 claims costing £35 million. So already there's a significant increase in the scale of the claims facing Post Office by September 2020, yes?
Yes, that looks right.
And it goes on to say, please note that there are a few exceptions to the deadline, notably the cohort of circa 6,200 former postmasters who were identified late by Post Office and notified about the scheme in July. So it must have been clear by September the significance of the claims facing Post Office. Would you agree?
Yes.
And the inquiry will hear evidence that it became clear that the Post Office could not afford to meet the HSS in November 2020. Do you recall that?
I don't remember the exact date, but that sounds perfectly plausible.
And that it then took 4 months to resolve funding within government to meet the HSS.
Yes.
Do you remember that? Do you recall why it took 4 months to resolve the funding issues?
I think this is going to be a not very attractive answer, but 4 months is not particularly slow in the context of resolving funding issues. Sort of in between spending reviews, going back and asking for more money for things is really difficult. So I sort of say that by way of context. The second issue is that at this point, this is effectively the first moment at which HMG says we are fully taking on the financial responsibility that comes with by this point we knew, right, that this was not the only compensation scheme that we were talking about, because the other issues were queuing up behind. So that was quite an important principled decision that was taken during that time. So yes, first of all, it's about getting money signed off and being able to demonstrate why it's the correct number, and going back and forth on, are you sure it's really this number? How much money do you really need? Where are we going to get it from? BEIS, can you find it from your underspends? Do you really need extra money from HMT, etc.? But it's also it's quite a pivotal moment, because it's the moment where, in effect, HMG sort of takes a financial liability that ultimately by this point was clear was going to be over £1 billion in aggregate, sort of takes it onto the public purse. Now, by the way, I'm not in any way suggesting that that wasn't 100% the right thing to do, but it is a swallow. And I think it took a bit of time for the system to make that swallow.
Could we look, please, at page 28 of your second statement?
Perhaps I might just add, apologies, I was thinking while you were pulling the document up, that it's also true to say that the kind of obligations that the Treasury likes least are open-ended, difficult to quantify ones. So that's why it's a difficult call, because you sort of knew that the number was going to go up. And however important, however worthy the case is, those are not numbers Treasury likes to deal with, because they really make a mess of the kind of bigger picture of the financial forecasts. So it's just worth noting that it's not just, if it just was a one-off bill and you knew exactly the size of it, it's sort of one picture, but a bill that you don't know the size of, that you're going to be committed to over multiple years in an unpredictable manner, that's just particularly challenging from a public finance point of view. Right that government took it on, but I think that would be one of the reasons why it took a bit.
So do we take it from your evidence that it took 4 months because, firstly, it was a big decision, secondly, it was a difficult decision, thirdly, for the Treasury, and thirdly, 4 months in the grand scheme of things for the government isn't a long time for a funding decision?
Yes, I'm not sure I would say it was a difficult decision exactly, because I don't really think there was any sort of meaningful... It's not like there was a cohort of people who were saying, we shouldn't pay this. It was more just like... okay, really getting to grips with it, and sort of, as you always do with these things, kind of hoping that maybe the first number is too big. You know, when people come to you, and this is true in any element of public finance, whether you're the Treasury dealing with the department, or the department dealing with an arm's length body, or a Director General dealing with a directorate, people come to you and they say they want X, and the first thing you sort of do is you go back and you say, are you sure? Is that really the number? Are you sure it's not X minus a bit? Those sorts of negotiations, sort of trying to make the problem be less of a problem from a finance point of view, you'd expect that same kind of approach here. Even though arguably it's completely inappropriate here, I think that muscle is just like so deeply ingrained that will have been going on as well.
If we could look, please, at paragraph 59. Thank you. You refer to an email from Carl Cresswell to you on the 26th of April 2021, update on the compensation next steps. And you highlight, it looks increasingly likely to me that we should consider taking on responsibility for the design and delivery of the compensation scheme within BEIS, though that would have large resource implications. And we see it, sorry, for 58, just to orientate us, you're talking about the question of ownership of OHCS. If we then go to paragraph 60, please, over the page. You say, I agreed with Mr. Cresswell that this was an issue. What was your position on whether the government, the department should take ownership of the design and running of the scheme?
I don't think at that point in the chronology of sort of receiving Carl's email, I would necessarily have immediately jumped to a position, but I completely agreed with Carl that we needed to look at it seriously, and it was a really important question, and it was one we were going to have to face into and address. That's what I mean by I agreed with Mr. Cresswell that this was an issue.
If we look at the briefing that followed, please, we've looked at it already, it's BEIS 40990. Have you had a chance to review this briefing recently?
Yes, I've seen this document recently.
And did you contribute to its drafting?
I couldn't tell you. I wouldn't imagine terribly substantially. It wouldn't be usual for me to be involved in the detail of a piece of drafting like this, but I may have commented on it.
We see that it's for the Secretary of State to approve, decide Post Office ownership of criminal convictions. And if we look, please, at page 3, paragraph 12, which I erroneously tried to go to earlier, says at the end, whether or not to take on direct responsibility is a delicate decision, so we would welcome your views in light of the following analysis. Is it fair to say that in this briefing there wasn't a suggested course offered for the Secretary of State?
That's right.
That can come down, thank you. Was outside of this written briefing, did you advise the Secretary of State on a position to take at any point in respect of whether the department should take over the running of the scheme?
Not that I recall.
We know that in your documents they refer to the fact that the Secretary of State said that made a decision. Were you involved in the decision-making process in the sense of advising him on that?
Not that I recall, although I couldn't absolutely swear to it. I mean, what I do know is that at the time, perhaps you say this is sort of typical, but this was another one which I thought was pretty finely balanced. So I didn't have I wasn't pushing a particular perspective, because I think if I had felt very strongly that one answer was correct, then I would have pushed for the advice to offer ministers a much clearer perspective. But ultimately, I think we all thought that this was quite a difficult call and one that ministers should make.
So from your perspective, the decision to keep it with Post Office was a ministerial decision without significant steer from the civil service?
With advice around sort of the pros and cons, but not, I don't think we pushed ministers into one option or the other.
Could we look, please, at your statement again, page 31? Second statement, sorry. At the bottom, please, paragraph 64, you refer to the GLO scheme. So even at the beginning of my tenure, it was obvious that the GLO settlement had, while being legally sound, caused a deep natural injustice, as those involved received so little money in their pockets after legal bills were settled and the litigation funders received their slice. And you refer to the scheme being announced. If we go over the page, please. So this was, in the early part, probably due to a conceptual assumption by officials and ministers that the GLO settlement had closed the book on this issue. Obviously, this was legally true. The relevant postmasters had no further legal claim against Post Office, but it was not morally true. But by Carl Creswell's email of May 21, we were clear we needed to act. This proved difficult to make happen. It took significant time to find a legal means to pay the money, which I think you were referring to earlier in your evidence when we were discussing a legal basis for making payments.
Exactly. This is a very hard constraint in the sense that the department literally just cannot pay out money without a legal basis. It's not a sort of matter for opinion or judgment. We didn't have a legal basis as we understood it. We later found one, and therefore we couldn't make the payment until we had a legal basis. And that's got, just to be clear, legal basis here has nothing to do with the legal claims or anything like that. It's a parliamentary ability to spend. Yes. You can only spend in line with the authority that Parliament has given you.
And at 66, you say this problem was real, and I think BASE and HMT officials did a good job at locating the Appropriation Act option. It does, of course, raise the question why His Majesty's government didn't just legislate to create spending authority, rather, as eventually happened in 2024 under the Post Office Horizon System Compensation Act. I think the answer comes back to my point above about the extent of radicalism both officials and ministers were contemplating. emergency legislation of this type is exceptionally difficult to make happen and, speaking frankly, requires an enormous head of political steam to have built up. Why do you think a sufficient amount of political steam wasn't there to push through a specific piece of legislation such as this?
I think two reasons. The first is, as indeed turned out to be true, a sense that had we really turned over every stone to make sure a spending power didn't already exist. So it's obviously, in the situation you find yourself where you think, oh, I don't have a spending power, it's obviously much preferable to find that you actually do have one, rather than to run a very unusual piece of legislation designed to create a power, very specifically around something like this on an emergency basis. That's it's very much out of the ordinary. That doesn't mean it's not a good thing to do, but people would always turn to what do we have, what do we have, what do we have? And I think there was as there often is when you're searching for something, you think you might find it in the first week, and then you think, oh, I'm going to find it in one more week, and you sort of keep going looking for it. And in the end, we did find it, but it took a while. How could you have shortcut that process? We could have found it faster, but it was pretty obscure. Or we could have just said, stop looking, I'm just going to legislate. But finding parliamentary time is really hard. And so I think all throughout, not that the question particularly came up in that form, but I think ministers would have probably said, like, okay, just before I go to what will be a very difficult parliamentary journey, could you just be really, really confident that you definitely haven't got one?
Was there sufficient consideration of the effect the delays were having on the sub-postmasters who were affected by the absence of compensation payments?
Good question. I think there's probably a bit of sort of boiled frog going on here, in the sense that each little individual bit of delay to look a little bit longer to avoid having to pass legislation probably didn't seem that bad. You always think, oh, it's worth looking just a little bit more, it's worth looking a little bit more, it's worth looking a little bit more. Each marginal extra bit of time makes sense, and all of those little ones are manageable from a postmaster point of view. But when you look at how long the whole thing took in aggregate, you say, how can you have taken so long? You should have done something completely different at the start. But the problem doesn't arrive at you in that form. You constantly think you're about to find something.
So that's probably a good time to take the afternoon break. If we could come back at past.
Yes, certainly. Yeah, fine.
Thank you, sir. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. I'll carry on. Please, can we bring up Bays 40975? We see this is a letter to Nick Reed from you dated the 29th of September 2021. Paragraph 2, you see it says, it talks about, on account of the management and control of Post Office Limited's litigation costs not being adequate, I am unable to release the payments due to Post Office, due until Post Office can demonstrate satisfactory control. Payments will be made by Bays following a shareholder-approved budget. So what you're referring to here is withholding the network investment and network subsidy payment because the department's position was that Post Office hadn't got control of its litigation costs. Is that fair?
Yes, litigation costs meaning payments to lawyers.
Would you accept this was quite a drastic step to take in terms of the levers that you can pull withholding payments to Post Office?
Yes, and only done after, shall we say, exhausting persuasion as a tool. It is worth saying that, of course, before we did this, we did analyse whether it would actually sort of cause an immediate operational challenge to POL, and we didn't think it would.
Pause you there, because my question is, did you ever consider doing something similar to put pressure on Post Office to increase the efficiency with which it dealt with ski applicants to the various schemes?
No, I don't remember that being proposed.
Why not?
I don't know why people didn't propose it to me.
Why did you not consider it?
Indeed. Sorry, I just thought it was important to clarify. I don't know. Ultimately, probably because we never quite got to the point where there was resistance from Post Office. So I would say on legal costs, by the point of this letter, there'd been a long period of debate around it, and certain people on the government side, in both the Treasury and UKGI, felt really strongly about this point and felt they were just never, ever sort of breaking through and getting the right traction. And Post Office's position at the time was like sort of resistive, as in, we have done all we can, there is no more, we are not doing more. And so there was a kind of sufficiently clear clash to make that feel like an appropriate move. I don't quite remember on pace ever reaching that point where you had a sort of like an ask and a resistance. It was more like ongoing pressure, ongoing movement. It got a bit better, it got a bit better, it got a bit better. And so there was probably never quite the like triggering moment where that sort of like specific intervention felt like the right thing to do. That's my best answer. Although, as I say, it's always hard to say, you know, if something didn't come up, why it didn't come up. But that would be my best interpretation.
Did the department not, was the reason why the department didn't run into the resistance as you've described because it simply didn't push Post Office hard enough on the compensation schemes?
I think it was probably more like, let's say, on HSS during those relatively early days. You know, the scale of the response set up in Post Office wasn't robust enough, as discussed, because they had underestimated the scale of the challenge. But as it became clear, they were moving. It's not like the dynamic was we were saying, get a move on, make this happen, and the Post Office was saying, we don't agree, we don't think it's important, we're not trying. They were saying, yep, we're scaling up the team, we're getting going, we're putting this in place. So there was a sense of responsiveness it was ongoing. You know, you push a bit more, you get a bit more, you push a bit more, you get a bit more. But I didn't feel that the post office was not responsive to asks. They couldn't always enact them because sometimes you can't kind of flick a switch and make something happen overnight. But they weren't kind of rebutting or denying them, if that makes sense.
If we look, please, at base 40967. This is a letter to you from Lisa Harrington, Chair of the Post Office Remuneration Committee, on the 4th of October 2022. And we say, I'm writing to you to apologise for the situation we find ourselves in regarding managing public money and the payment of the CEO's short-term investment plan. And further down, it says that, effectively says that the CEO's STIP payment was paid without shareholder approval. Is that broadly the issue?
Yep.
And that's been raised directly with you to deal with because it's a matter of managing public money.
That's right. So it's come to me as accounting officer.
Okay. Could we look, please, at WITN 115-20201. This is a readout of the call you had with Lisa Harrington on this issue. It's the date is, the email sent on the 28th of October 2022. If we go to the bottom, please, it says that SM, that's you, noted that if we looked at this cold without breach, the likelihood is we would have approved. However, noted that it will be tricky navigating ministerial approval, discusses issues of flight risks, and then suggested next steps at the right at the bottom, says UKGI based to rework advice for ministers around the retrospective approval will need careful handling. Do we take it from this that your position was that the minister should be guided to retrospectively approve the STIP payment?
Yes, on the basis that it would have been approved in the first place had it been asked about in the proper way by the Post Office, and the fact that a serious mistake was made in governance in not asking for that permission shouldn't ultimately be a reason not to do what we would have done in the normal course of business in terms of approving what is ultimately really a Post Office decision about the STIP.
Did you have any similar meetings with members of the Post Office Board about to test Post Office's approach to the compensation schemes?
No, and I'd like to say why this meeting took place, because I think it's important to understand. This wasn't a meeting that took place because I thought or any of my team thought that the STIP was ultimately a really important and strategic issue. It's because failure to comply with your duties under managing public money and to do what's described here, that's the right language, as a breach in managing public money, it's a really serious error in compliance. Now, in this case, it's actually not that big an error, right? I mean, in the grand scheme of the things we're talking about, this is in my view, insignificant matter in the big picture. But the fact that an arm's length body commits a breach of managing public money, I can't remember ever seeing it. And I would absolutely expect, just as a matter of course, that would come with a letter of apology and a personal meeting in order to apologise, frankly, to sort of put on record that the seriousness of the fault had been recognised and that systems had been put in place to make sure it didn't happen again. Not in relation to the STIP payment, but in relation to the bigger picture of, back to the sort of regularity issues we were talking about earlier, you just can't have public bodies ignoring or flouting kind of core rules of how public money is administered. So, you know, the fault itself is ultimately a relatively insignificant one in the big picture, but the fact that any fault of this type would take place is a really serious matter, and it's kind of a disciplinary type affair, and so you're bringing in a particular kind of energy, which is you are meeting the accounting officer. This is a kind of a moment of formality, I would say.
You were the permanent secretary during a period of time in which this inquiry held compensation hearings, is that right?
Yes.
And you were aware of various criticisms that had been made against the Post Office and the department in the way the schemes were being funded and run?
Yes.
Why was that not of sufficient importance for you as permanent secretary to meet with board members to discuss those matters in particular?
Well, I did meet with board members. I met regularly with the chair, so that was a normal part of the course of doing business, and those are exactly the sorts of things I would discuss regularly with Tim Parker, and I met with the CEO as well, so I was engaged in all sorts of different ways.
So my question was a specific meeting such as this set up to discuss compensation schemes in particular?
Because the nature of this meeting was the right person, sort of the offence was an accounting officer offence, if you see what I mean. So I was the channel that this needed to go through. So I was the appropriate escalation point for this kind of issue. There were a whole series of different bits of governance going on around all of the various issues that came up with the inquiry, including the inquiry itself, very regular ministerial contact, regular contact with the board. This was a sort of quite a specific and different channel. I wouldn't have usually felt this was a normal approach to a important issue. I would normally take an important issue to the chair, the CEO, sort of more in the course of an ordinary series of meetings rather than have a kind of an accounting officer censure moment.
I want to turn to one of those meetings, please, and that's the meeting with Henry Staunton, which is predominantly the focus of your first witness statement. You say in your first statement, we don't need to bring it up, page 6, paragraph 17, in response to the allegation well known to the inquiry, you say, I never told Mr. Staunton directly or indirectly, expressly or by implication, that Post Office should stall on compensation or otherwise delay or reduce compensation payments to sub-postmasters. I did not say anything that could sensibly have been understood to convey that implication.
That's completely correct.
Could we look, please, at base 40607? This is your letter to Henry Staunton congratulating him on his appointment. And if we see at paragraphs 2 and 3, you say, each year I write to the chair to set out the key strategic priorities that BASE, as sole shareholder, would like the Post Office to focus on over the coming 12 months. Early this year I wrote to Tim Parker, the outgoing chair, setting out the strategic priorities, and you would say you attached that letter. You're in effect asking him to take over and continue the work that you set for Tim Parker. Is that fair?
Yeah, with a particular focus on the 3 points that I specified below.
And those 3 points that you specified below includes effective financial management and performance, including effective management of legal costs to ensure medium-term viability. And I understand your evidence is that when you say legal costs, you're referring to litigation costs, namely the cost Post Office pays to its lawyers, rather than compensation payments.
Yes, that was very well understood between us and the Post Office at the time.
Could we look, please, at the letter to Mr. Parker, which you referred to, which is base 40984. think it's undated on this copy, but in your statement you say that this was sent on the 23rd of May 2023. If we could go to page 2, please. Sorry.
It can't have been sent in May 2023.
Sorry. Sorry, 2020. It must be 2022. Sorry, that's an error in my...
No probs.
Page 3, please. So this is under the heading on the second page, resolving historical litigation issues. And thank you. If you can go further down, thank you. It says at the bottom, we see, it is right that these issues receive the attention they require to ensure their swift resolution. For financial year 22-23, Poll should, and then there's an indented paragraph. If we could just go down slightly. Thank you. It says the last entry there is challenge post office management so their activities are reflective of our shared objectives for compensation, to see postmasters are treated with consistency and they receive swift compensation that is fair for claimants and taxpayers. What do you mean by fair for claimants and taxpayers?
I think this probably goes back to what we talked about earlier about value for money. I think you'll see it in some other letters written to Tim at other times that talk about value for money. And ultimately, this is about saying, we need you to pay full, fair and prompt compensation, but that should be done without wasting money on lawyers, without wasting money through fraud and error, and compensating fairly. Generously, fairly, appropriately. But that clearly is different from a process that starts from the premise of, taxpayers have no interest here whatsoever, and it doesn't matter how much you spend.
How do you read generously into that paragraph?
I'm sort of paraphrasing to say that our objectives for compensation were for it to be full, fair and prompt. It is consistent with that to care about the interests of taxpayers and to want full and fair and prompt compensation to be delivered in a way that protects value for money, i.e. in a way that makes sure that you're not wasting money as you do it, just as any other government goal. If you want to build a power station, build a nuclear power station, let's say, you should do that in a way that is fair for taxpayers, but it should still be safe and it should still be operational. It should still be full and fair.
Mr. Staunton's evidence was that effectively as he took it, a message to say that the government did not want compensation to be overly generous. Would you agree with that?
No.
Why not?
Well, I am shocked that if that was what he thought, he never raised that with us at any point. So I don't agree that he has that reading, although I understand that is his evidence. And that isn't what we meant in writing it. Because if we were stepping back from the ministerial objective of fulfilling full and fair and prompt compensation, we would have needed to say so. Nobody ever told us to step back from that. Nobody ever indicated we should step back from that. There wasn't any advice provided either to me or to ministers that we were stepping back from that. So that wasn't our intent in writing this, and I don't believe that's how it was read by those receiving it.
So just so I understand your evidence, is your evidence that full, fair and prompt also means generous compensation?
No, I don't think I'm saying that. I'm saying that full, fair and prompt compensation should be delivered in a way that is fair for taxpayers, but that doesn't mean that it should not be full, fair and prompt. Full, fair and prompt is the first requirement. Within that, like everything else, whatever you're doing in government, you want to do it in a way that is as fair as possible for taxpayers, which essentially means don't waste money while you're doing it.
Can we look, please, at the briefing for your meeting with Henry Staunton?
Before we do, Mr. Stevens, the paragraph that follows that, Miss Munby, and its use of the word balancing, if you read that sentence to yourself.
Yeah, I've looked at that and reflected on it, actually. I'm not sure balancing is a good word to use in this context. And as you can imagine, of course I signed the letter and I totally stand by it, but I didn't draft every line myself. And as I sort of look back on it, I think that sort of balancing isn't really the right way of talking about this, certainly when it comes to fair compensation. I do think balancing has some role when it comes to pace and swift compensation. It gets more complicated in that case because you can go faster at greater expense or not. And that's something that the National Audit Office talk about in their lessons learned report. That sort of, when it comes to full and fair, it's quite straightforward to say that isn't a trade-off with value for money or with fairness to taxpayers. I think it's in pace of delivery that you start to see that balance maybe begin to bite. And I think that's probably the use of swift here, I think kind of indicates that's what's running through the mind of the person drafting it.
Yeah, all right. It's those two, the indented last paragraph and that paragraph, which led me to ask questions both of Mr. Staunton and Mr. Cameron about whether they thought that issues like value for money were being taken into account in terms of individual payments, or offers rather, to postmasters. And they both, at least as it seems to me at the moment, thought that that might be happening. Now, you wouldn't know what was happening in the actual administration of the HSS and the overturned convictions process, obviously. But do you think that those words in that letter might have contributed to that sort of thought process?
If they did, I'm sorry, that certainly wasn't the intent in writing the letter. I think it's just maybe useful to note that you're back to managing public money. It says very explicitly that value for money is always a consideration, including in compensation schemes. So from my perspective, when I was reading either this drafting or the drafting in other letters, I wouldn't have felt there was anything particularly unusual or radical in mentioning value for money in the context of a compensation scheme. Indeed, that's what managing public money, which is sort of the Bible when it comes to these things, itself does. So I'm sort of reflecting that overall point of view of government as a whole. I think there is a very big difference between saying, you know, looked at as a whole, you should deliver compensation in a way that is value for money and doesn't waste money. That shouldn't be, but I totally understand what you're saying, Sir Wynne, that it may have been, but that shouldn't be taken to imply that an individual claim should be settled at anything less than full and fair, which was the ministerial intent throughout.
Well, that was my last question, really. Whatever may be said about those couple of sentences in that letter, so far as you were concerned, when you were permanent secretary, did your political masters ever deviate from the policy objective of delivering full, fair and prompt compensation?
No, I think they and we and the Post Office could all be criticised for whether that was always, you know, implemented in full. And there's lots of debate to be had about that. But in terms of intent, absolutely not.
Right. All right. Thank you very much.
Just one point arising from that. When you were thinking about, you said full, fair and prompt, you refer to fair, by what standard would you refer an offer to or compensation to determine whether it was fair?
Well, I mean, ultimately, I think that's a question that goes to ministers and what their intent was, just to be clear. It's not for me to sort of be the arbiter of fair. You know, and indeed, I think the schemes, if you look at what HSS says, it sort of goes so far as to say that fair may be greater than the sort of legal obligation, but it doesn't particularly give a exact, precise definition of fair. I think it uses, I'll get the wrong exact expression, but it's something like sort of fair, fully in the round, looking at everything and bringing it all together into a rounded view. You know, fair certainly means at least what you're legally entitled to. That's probably a flaw, as it were, on fair. But I don't think it defines exactly what fair is. You would think that that would be sort of set by kind of the moment of approval of the sort of terms and arrangements of any individual scheme. You know, what did fair mean in that context? You know, fair means something different when you're talking about overturned convictions than when you're talking about shortfalls, for example.
Could we look, please, at base 40631? So this is your briefing for your introductory meeting with Henry Staunton. And if we scroll down, please, we see the agenda. We have first is CEO pay, then NED appointments, finances, recent correspondence, and so on. Over the, well, at page 4, please. If we go down. Thank you. We see under 4, which was recent correspondence, we have references to the overturned historical convictions and historical shortfall scheme with some briefing on that. Why was CEO pay at this stage at the forefront of your agenda in the briefing rather than the compensation schemes?
Because Mr. Staunton had just written to the department about it.
So it was reactive, basically.
Yeah, this is an initial meeting with somebody. I haven't had anything from him so far, if you see what I mean. It's a new slate, but the one interaction we have had is a letter from him to the Secretary of State asking about CEO pay, so it would be just normal to respond to that. It's also just perhaps worth saying that that's an agenda prepared for me by the team. You'll note, having seen the readouts from the meeting, that I didn't take the agenda as a gospel of exactly what would be covered in the meeting. I just think it's worth saying that.
Well, okay, well, let's look at the readout then. It's base 40752. Excuse me. So this, if we go to the bottom, please. This is the readout prepared by the department, and we'll come to the first sections in more detail shortly. As I understand your evidence, but tell me if I'm wrong, the discussion on compensation, you say, is further down. If we go down, please.
Not quite, no. Actually, we didn't talk about compensation at any great extent in this meeting.
Okay, that I take that point, and that's your evidence on that. But where it says HS mentions target ref in inquiry hearing, wasn't looking for an apology, but wider point around being synced up and acknowledging where each other's roles lay, was keen him and Sarah strategically aligned where possible. Was that a discussion about compensation, something that had been said in the inquiry hearings regarding post office's meeting targets.
That's right. That was, I believe, it was either a Bayes or a UKGI lawyer misspoke and suggested that 100% was a target rather than an aspiration, and Poll were upset because it made them look like they hadn't met the target when in fact they had met what was the target, which was 95%. So it was a relatively minor point in the grand scheme of things, but Post Office felt we had, unfairly represented them in front of the inquiry, and that was a fair point. It was a mistake, and we apologised for it.
And just to clarify, is your evidence that that was really the extent of the discussion on compensation?
Yes.
Why did it play such a minor role in your first meeting with the chairman?
Well, I think there's probably two reasons for that. One is, and they sort of go one on each side, right? So first question, why did Mr. Staunton not raise it as a major issue with me? That would be a question for him, but he didn't. So it wasn't like I was responding to any prompting around it.
My question's to you about your
Understood. So why didn't I raise it with him? It's quite specific to the context, actually. So he'd just been recently appointed, and I'd been involved in the appointment process. And I was actually really, at that point, very pleased with this appointment, because Mr. Staunton had real hands-on experience, particularly from his role at WH Smith, in helping turn around performance at a business that, of course, no business is the same as Post Office, but WH Smith has some, quite obvious sort of commonalities with the Post Office. And of the various perspectives that I wanted to get from Mr. Staunton particularly at this point, I was really interested in what would a serious, experienced commercial leader who had sort of done a similar kind of a job before in turning around the performance of a really challenged high street business. I really wanted to understand his take on that. And in my mind at this point, correctly or not, I imagined that Mr. Staunton's personal focus would be, in very significant part, on the commercial turnaround of the Post Office, because that was his experience and that was what he was bringing to bear. So he was very new in role. At this point, I could have asked and inquired lots of things about the compensation work, but I think my perception would have been he needed a bit more time on that to really come up the curve, whereas I was, to be honest, hungry for what he was going to say about the commercial performance of the Post Office, because as you'll see from the briefing documents that run up to this meeting, as well as being concerned about compensation payments, we were acutely concerned about the strategic and financial position of the Post Office as a business and its viability and future. And I was really worried about that, and I really thought Henry himself, Mr. Staunton, I'm sorry, would have a lot of value to bring to it, and that was the conversation I most wanted to have with him.
So you most want to have a conversation about the commercial issues. We saw it earlier in the letter to Mr. Parker and the letter to Mr. Staunton that achieving settlements was a key strategic aim for the Post Office.
Yes.
And did you see, as part of your role, ensuring that the chair took that strategic objective seriously?
Yes, I didn't use this as a meeting to run through the strategic objectives for the Post Office. You can see there isn't a sort of, let me recap my letter. That wasn't how the meeting went. I would have assumed that he had sort of taken those points as read. They'd been formally transferred over. This was meant to be more of a... I don't mean off the record in a formal sense, but just a bit more of an informal chance to exchange views about the situation, for him to offer me some perspective and for me to offer him some advice as someone new into role.
If we look at the start of the note, please, it's the bottom of page 1. It says that SM flagged that the relationship on funding with the Treasury is difficult. Their view will always lean towards the begging bowl type scenario, a dynamic worsened by horizon/inquiry costs. What are you referring to by the begging bowl?
There's been a long-standing goal of government including Treasury, but government as a whole, that Post Office should move to being self-sustaining from a financial point of view, i.e. that it shouldn't be reliant on government subsidy. We can come to discussion about whether that was a realistic or achievable goal, but that was the stated position of government. And in that context, Treasury in particular, throughout this period, long predating this conversation, Treasury in particular had a long record of basically being sceptical of Post Office's claims that it needed government subsidy and believing that what Post Office should do was focus on improving their own performance, sort of getting their own house in order, strengthening their financial and strategic position so that they wouldn't need government subsidy. And I think a real sense that there was a risk of essentially sort of creating easy money. And if you create a sort of path of easy money for a corporation, you lessen their incentive to improve their own performance. And that perspective, that's what I'm getting at with the sort of begging bowl. They're sort of always asking for more money. That was how Treasury saw Post Office when it came to asks for subsidy. They believed those subsidies should be going to zero and the Post Office should be weaning themselves off those subsidies. And they were sort of, irritated is not quite the right word. I can't bring the right word to mind, but they were sort of frustrated by the constant asks for more and more money.
I'm just going to have to stop you there, given the time. I've got that point. The dynamic worsened by Horizon inquiry costs. Where it says Horizon costs, is that referring there to settlement costs, namely costs associated with the fallout from the Horizon issues?
I couldn't be 100% sure. It could equally be referring to Horizon replacement costs. It's a bit...
It would be unlikely, wouldn't it? It's for those to be together. It's more likely, would you not think, for Horizon an inquiry cost to refer to, one, the costs of the inquiry that arises from the Horizon issue, and two, the costs associated with compensation that arises from the Horizon issues?
Not necessarily, because Henry had just talked about what the big financial pressures were on the Post Office, and he talked about Horizon replacement, and he talked about rising inquiry costs, and he's talked about telephony. He hadn't mentioned compensation costs because, of course, those came from a different budget and were not really part of this dynamic that we're discussing here.
Mr. Staunton's evidence was that effectively the message was that he could not expect significantly more money to be forthcoming from the government, even if he thought the remediation schemes needed it. Would you agree with that position?
Absolutely not. I do not believe that is a plausible thing you could take away from the conversation we had in any way.
Why are you so confident on that?
Because I don't think that explanation makes any sense given the conversation that we had. The conversation that we had was about my efforts to try to secure more money for the Post Office. So if you go further down in the note, we're discussing how difficult it is, basically this scenario of HMT don't want to give the Post Office more operational subsidy. And I'm talking about why is that difficult? You've got to make trade-offs within budgets, you've got to manage subsidy control legislation, and specifically, HMT at the time had a very clear policy that they wouldn't provide more subsidy to the Post Office in the absence of a long-term strategy, and we didn't have a long-term strategy. So what I was describing was a set of difficulties about securing operational subsidy. I never said anything about difficulties of securing money for paying compensation. And Mr. Staunton himself never mentioned any difficulties with funding for compensation. Indeed, as you rightly point out, the issue of compensation was broadly speaking not discussed, which you can criticise for other reasons. But it is inconceivable that you could have understood me to be saying, don't spend money on compensation, when what I was saying, as is recorded in the readouts, is I'm going to try and get you a bit more money to deal with these really big operational and strategic challenges you're facing. But I want you to know it's not that easy to do that because of these kind of practical difficulties of getting money over the wall. None of which apply in the case of, like subsidy control, for example, isn't an issue in the case of the compensation money.
Could we look, please, at Mr. Staunton's note of the meeting? It's base 40918. And if we go towards the bottom, please. It says she also referred to operational issues colouring the Treasury's thinking. Trust in the Post Office Board and management has not been high. They could see this as another begging bowl, so we see the same words used there, request from the Post Office. I said the funding issues revolved around poor decisions made many years ago, Horizon and WRT Horizon, sorry, and related legal issues. Do you accept that that's an accurate note of the conversation that happened?
I think it's just worth saying what we were talking about there by Horizon and related legal issues. Just if you sort of go back to the beginning of the conversation, Mr. Staunton had laid out these three big, new, difficult cost pressures that the Post Office were dealing with. One, which I think is sort of smaller and less relevant, was the telephony issues. One was the Horizon replacement system. And one was the costs of responding to the inquiry, i.e. the costs of gathering the evidence, working with the lawyers, etc. Those were the 3 points that he laid out at the very beginning of the meeting, and he's playing back 2 of those here towards the end.
So just so I'm clear on your evidence is that what was discussed was, amongst other things, the cost of replacing Horizon. Was that?
Yes.
Yes. The costs associated with the inquiry.
Yes.
But your evidence is compensation itself wasn't discussed.
Yeah, I mean, it might be worth going to the bit in this note where those 3 points are laid out.
No,
because it makes
we can
it
read
quite
the
clear.
note, that's fine. But that's just so we're clear on
Yeah,
your...
absolutely, yes.
Okay, we've got your evidence, thank you. That document can come down, thank you. What are your views on Mr. Staunton's competence as chair while you were permanent secretary?
I had very little interaction. We overlapped by a very short period between his appointment late in 2022 and me moving on to the Department for Science, Innovation and Technology very early in 2023. So I think it would be totally unfair to draw any conclusions about his performance as a chair during that period.
I want to look at a couple of points on what you say about the board effectiveness or improvements of post office governance. We don't need to bring it up, but paragraph 20, page 11 of your second statement, you say, I think post office's internal governance was very much improved, but still not adequate. I think that's by the time you left. Is that right? Can we look, please, at poll 20446476? This is a Post Office Limited Board Effectiveness Report dated the 19th of June 2024, so you wouldn't have seen it in your role as permanent secretary, but have you had a chance to review it in preparation for the inquiry?
Yes, I've seen it after being provided with it by the inquiry.
Can we look, please, at page 8? We've got some key findings there, including lack of clarity on the purpose of the board, with the shareholder relationship inhibiting the board's effectiveness due to perceived interference in post office's work, and limited visibility around the longer-term funding and objectives of the organisation. Was that a problem of which you were aware as permanent secretary, namely a query over the longer-term funding and objectives of the organisation from the department's perspective?
Absolutely, 100%, yes.
And in your view, had that been resolved by the time you finished as permanent secretary?
No, and if I may, just expand very briefly on that. We had for some time work running following the settlement at SR 2021, which was actually conditional on carrying out a review of Pol's long-term or rather HMG's long-term strategy for Pol, which is not quite the same question as Pol's long-term strategy. And we had done quite a bit of work on that, including getting to the point towards the end of 2022, i.e. briefly before that meeting with Mr. Staunton, just to put it in schedule, as it were, of trying to go to right round across government. That's the sort of approval process by which you get cabinet sign-off, right round to launch a more formal review of the long-term requirements of the Post Office by government, and ministers had declined that opportunity and said, no, now is not the right time. So I really recognise this complaint. I was very concerned. I was talking earlier about my level of concern about the sort of financial viability of the Post Office going forward. Of course, that was deeply associated with a lack of clarity about what the Post Office was in the long term there for. And at the time, and this is reflected in what I said to Mr. Staunton about the sort of, we need to hobble on, we need to find a way of managing under the strategic steer we already have, because in the short term, ministers were not ready to carry out the kind of full review of Post Office's roles and responsibilities that was really needed in order for government to more clearly define not just the branch footprint, but the services provided, the nature of the financial relationship. All of that needed fundamental refresh, in my view. But it was difficult to get ministers to sign off, I think partly because of, frankly, the political toxicity around the whole issue. And the fact that we knew that any review, sort of regardless of what it ended up concluding about the corporate structure of the Post Office, and I know there have been all sorts of proposals about different kinds of mutualisation and so on, but whatever you did, you faced quite a fundamental challenge that you probably either needed to really seriously increase the level of public subsidy to the Post Office, which had its own challenges politically, or be prepared to say that you needed many fewer Post Office branches, which is also a really difficult thing to say politically and incredibly difficult for postmasters as well, who were, of course, under enormous challenge during this period. And I think ministers were sort of looking at that really, really difficult choice and saying, now isn't the time, let's get through the inquiry, let's get through the compensation processes, and let's come back to this question in due course. But that did leave a period of really challenging ambiguity for Post Office, and I think that's one of the reasons why ultimately we did end up with, following Spending Review 2021, a series of what you might legitimately describe as sort of short-termist funding interventions, giving over some more money to Post Office to manage the Horizon Replacement Programme, to deal with the rising inquiry costs, etc. Sort of dealing with the problems as they arose, rather than fundamentally refreshing the strategy and rebuilding the organisation towards that new strategy.
Thank you. That document can come down. So I don't propose to ask any more questions. I'll see if there's any. Yes. Mr. Henry and Ms. Patrick have asked for 5 minutes each, sir.
Fine. I look forward to their accuracy in estimation. Who's going first?
I'm being forced to go first by Miss Patrick, so I shall go first, sir.
I've never known you to be forced to do anything, Mr. Henry, but there's always a first.
Thank you. Thank you, Ms. Munby. As Accounting Officer, Permanent Secretary until the 6th of February 2023, did you ever cancel an interim payment owed or even due to a sub-postmaster?
Not that I remember.
Did anyone do so on your behalf, cancelling an interim payment agreed with the sub-postmaster?
They may have. I'm not sure what on my behalf means, if you see what I mean. Certainly not at my request.
Certainly not at your request, but obviously under your aegis, because of course you're the Permanent Secretary, you're the Accounting Officer. Do I take it from your answers that you were unaware, and I'm not suggesting necessarily that this did occur on your watch, but that you, I'll rephrase it, particularly since I've got very little time. Did you ever become aware of interim payments being subject to a moratorium?
I don't recall that.
Right. You see, we've heard evidence yesterday and today from Mr. Ricaldin that such practices were occurring in your successor department from January this year for some months. And he said, among other things, and I'm going to, the transcript I don't think is on relativity, but I'm going to read out a little bit to you so that you're familiar with it. I omit words, but this is at page 48 of 86, beginning at line 11, page 191 in the internal numbering. In OC, there are many opportunities, as I explained earlier, to pay out more, further interim payments. And what the department was saying to me was, no, we don't want you to do that. That's not the objective anymore. We'd rather you hold on to those and hold out for settlement. I emphasize the word hold out. I was extremely uncomfortable with that, and I think I'm making my point articulating of what is the right thing to do because I didn't want to delay. It seemed to me I was getting an implication to delay redress in order to hold out for full and final settlement. And then I omit words, and this is the facing page, line 7, 192. That was the moral dilemma that I was facing. And they made it clear to me, absolutely crystal clear. No, Simon, the objective, it's there, black and white, full and final settlement. So I then had to issue instructions internally to say those potential interim payments, the government will not approve them now, and they didn't approve them because they were holding out for full and final settlement. Now, that coming from Mr. Ricaldin today and yesterday is an extraordinary state of affairs, you would agree, in your successor department. To cancel agreed interim payments that had been notified but would now not be approved because the department was holding out for a full and final settlement. Notice the absence of the word fair. That would be an extraordinary situation developing from January of this year. You must accept that.
I mean, I haven't heard any of that until just now. So, you know,
so what's your reaction?
My reaction is that doesn't sound right, as you've just put it to me there. The only thing I've heard of that's similar, so I think the only thing I can sort of draw on from my experience, is in the very early days of HSS, I do remember there being discussions about the merits of introducing interim payments or not. And one of the arguments that was made at the time, and probably one of the reasons why we were, in my view, too slow to introduce interim payments in the first place, was about the question of whether kind of efforts to provide interim payments would actually delay making final payments, and that would be bad for postmasters.
Or would it actually, worse than that, expedite settlements at an unrealistically low level because postmasters had been starved of cash? It was as if they were in a famine with the purse strings being tightened against them to force them into precipitate and unrealistically low settlements.
I mean, the language that you just used in describing the evidence just received, it does sound closer to that than to, you know, I'm making a balance of is a smaller payment earlier or a bigger payment a bit later better.
It does, doesn't it? Now, you know how the civil service works. Who would have given the order to cancel interim payments, even those most reprehensibly which had already been agreed?
I don't know.
Now, I must ask you to reflect very carefully on the answer you've given. You know how the civil service work. This is your successor department. I realise that it's not the same department that you were permanent secretary of, but can you help us, please?
I could have come from a few different places.
Such as?
It could have come from one of the oversight bodies. It could have come from one of the officials in the chain, a member of the senior civil service or the director general or the permanent secretary. It could have come from a minister. I suppose in theory it could have come from the Treasury because they were involved in governance. I'm not trying to be unhelpful at all. I don't know much about the case,
So
and I don't know
host...
therefore sort of where it might have begun.
Right, I see. Thank you. Nothing further.
Thank you, Mr. Henry. Ms. Patrick.
Thank you, sir, and thank you to Mr. Henry. Ms. Munby, I have very few questions of you, and I know that Mr. Stevens has covered quite a lot of detail about your witness statement and your reflections on when government can and can't take a radical approach to solving problems. And we know your witness statement covers the approach to Ukraine and the approach to COVID, for example. I'm not going to go back over that. And I know you've said you can't really comment on things that happened after you left your post as permanent secretary, and you don't want to comment necessarily on how the change of approach came about. But I'd like to look at a couple of your observations in your second witness statement, if that's okay. If we can look, and you don't have to turn it up, I'll read it for you, and you can trust me that I'm reading it from the page.
I know my witness statement reasonably well.
Indeed. So. At paragraph 72, you say, of course, in the round, looking back at events, an initial underestimation of the scale and depth of the challenge in truly delivering redress was then followed up by a plausible and incremental set of decisions on how to deliver full and fair compensation, with those decisions focused on deliverability, fairness, appropriate use of public money and good governance, justifying and building up the response piece by piece. And just stopping there, you said something a little bit like the boiling frog scenario.
Yep.
Yep. Such considerations are the mainstay of government, and we should not leave them behind hastily. However, we had begun down the path with a deeper and more complete, had we begun down the path with a deeper and more complete understanding at the start of the true human impact of all that had happened previously, I wonder whether both officials and ministers might have taken bolder, more radical decisions earlier that would have allowed us to reach towards full and fair redress faster and with less distress for postmasters. And I just want to ask you, did ministers, looking back with your reflection, see this scandal, this scenario, as a business as usual project that could be approached with business as usual solutions, always falling back to the usual principles of government and public restraint at the initial stages?
Broadly, yes, but business as usual is a very, very broad tent in government and includes doing absolutely extraordinary things that are very unusual. So I don't mean that they thought it was ordinary or straightforward or very much like everything else we were doing, but the distinction I was seeking to draw in my witness statement was I have seen a few, very few, but non-zero number of things in my roughly 5 years in the civil service where ministers have very explicitly said, from almost day one, I want you to put precedent completely aside. I am not interested in any of your useful, practical points about governance or managing public money. Just do it. Make it happen, and have sort of like broken the frame. And the two examples, I know you said them and I don't want to waste time, but the two examples where I've seen that were at the very beginning of the COVID crisis as it related to the survival of small businesses. and secondly, after Russia's invasion of Ukraine, as it related to preventing the very precipitate rise in energy bills for households and businesses across the country. Those are, when I say business as usual, I mean not that, rather than sort of saying it was seen as a sort of in a box with a load of things in the kitchen sink to be dealt with in a very ordinary way.
Indeed. And what we can see from, and I think taking from your evidence, is that it was only when ministers were forced by the political pressure to face up to the realities of this scandal and its impact on the individuals concerned, the sub-postmasters themselves and their families, and the impact that that was having on public consciousness. Then it was seen that this was an issue which needed a truly radical solution, which stepped beyond those, and I'm calling them business as usual prospects, and the underlying principles behind them.
Yes, I think that's a fair summary of my evidence.
And can we look just at one other section of your evidence? I just want to look at a part of your evidence on the briefing that was being provided to you. And at the very earliest part of your second witness statement, you say, with hindsight, you have two reflections. First, that the briefings were, perhaps unsurprisingly, typical civil service briefings, focused on the facts and next steps. I couldn't honestly say that they brought home the ongoing human tragedies at the heart of this case. And with hindsight, I think I should have personally pushed to meet with the postmasters myself. Second, I'm not sure that these emphasise sufficiently the ongoing cultural challenge at the post office. Now, that's reflecting on the briefing provided to you. Do you think there was a similar failing in the briefing that was being provided to ministers?
I think that sort of probably goes almost necessarily because there's a great deal of overlap in the briefings. I suspect, though, ministers, more conventionally as part of their role, will have been meeting postmasters at various points in this process, and of course, officials within the department and very extensively in the post office. I'm sure Simon Ricalden talked about the work that he did on that front. But I think the straight answer to your question is yes, I think that same criticism is likely to be true, indeed is true, of the briefings that were provided to ministers.
And no matter what sub-postmasters and those that were representing them and others may have been saying about this being the biggest miscarriage of justice in modern history, and about the impact on individuals who'd lived for decades, some of them, with the stigma and the harm that had resulted from the events of their prosecution. That ministers themselves at the outset may not have appreciated that this was a truly unique set of circumstances that really needed a radical solution.
I think it is difficult to calibrate when something moves into that radical space. I'm trying to think of sort of sensible analogies, but very terrible, challenging things happen an awful lot in government. Dealing with, widespread rioting across the country, or dealing with, a shortage of prison places. Just to take some examples, say, from the last 6 months or so. So the scale of what we're talking about in terms of kind of outrage, perception really has to be very, very, very high indeed. And I think it is true what you say, but I also just really want to emphasise that that doesn't mean that ministers didn't understand that this was a terrible, horrific injustice, or think that it was a really important priority to fix. And even within what I've described as a kind of incrementalist approach, and I appreciate that many would criticise it, but nevertheless it did involve committing well over £1 billion of public money, even within that frame, and that was a insufficient but serious response.
Thank you for your response. I was simply reflecting on your own evidence that there was a shift in perception.
Yes.
Thank you. I don't have any further questions.
Is that it, Mr. Stevens?
Yes, so that's it.
Well, thank you very much, Mrs. Munby, for making 2 witness statements and for coming to the inquiry to give evidence. Well, it's all been this afternoon, though I dare say you may have been here during part of the morning. Anyway, thank you very much. I'm very grateful to you, very grateful to you for helping the inquiry in the way that you have.
Thank you.
So we'll resume again at 10 o'clock tomorrow, Mr. Stevens?
So I think it's 9:30.
9:30, I'm so sorry, you're quite right. Yeah, 9:30 tomorrow morning.
Thank you, sir.